Good morning.
Item number one.
In this item number one, in fact, so may kindly have a glance at the judgment passed in this revision that is dated 23/6/2003. In fact, by this judgment, the Honorable Single Judge, he referred two questions to be answered by the division bench, that is in the year 2003. After that, it is being listed.
Why it is before the division bench?
Because there are two questions. Kindly have a glance at page 4 and 5 of that judgment. Dated 23rd June 2003. Also got it? Page 4? Yes. Therefore, the registry is directed to place the matter before the Honorable Chief Justice to consider the matter in a division bench on the following terms of reference. So two references are there. So these two references have to be answered now by this Honorable Court. Now, neither the brief is available. So I will answer, argue this matter and advance my what I pray is let it be listed immediately after vacation, and the soft copies may kindly be provided. I will supply the pen drives. The soft copy of this brief may kindly be provided, so that provide soft copies.
Okay. That's the request of the counsel for the review petitioner. Correct.
It's not a review. In fact, in the judgment itself, there is a reference.
But it's called as a CV.
That is civil revision. That is civil revision. That is civil revision. Simple. Civil revision.
Right. Call this matter the request of counsel appearing for the civil review. Call this matter. Will fix some date?
Yes, no problem. Maybe Friday or something like that.
On
any Friday, it will be better.
Friday? 24?
24.
Okay. 24. Item 2?
Item 2, my lord.
Registry to make available.
Soft copy.
Soft copies. Okay.
Item 2, my lord, after the review petition, it was allowed, my lord. The lead petition was restored before this Hon'Ble Court. First time after the review was allowed.
Review was allowed and matter is restored to the board for consideration afresh.
Yes, my lord. Hearing matter, my lord. Magistrate senior to appear in this matter.
2019 matter.
My lord. Recently it was restored in the review, my lord. There was, in my lord's bench, the coordinate Honorable Justice was actually conducting counsel in the same matter before. That's why the review was allowed, my lord.
Okay.
After that, this petition is fresh before your lordship.
All right, we'll have this on the same day.
All
right,
24.
On 24, at the request of the counsel appearing for the petitioner on the ground that arguing counsel is not available.
Appeals Court. On the Appeals Court directed the state government to reconsider a case by taking note of the rules have prevailed at time of the death of the employee.
Immediately.
This case by covered middle or
Up to it.
Some fresh admission matter also I prefer tomorrow matters. Regularization matter, fresh admission matters.
Fresh admission.
Matters.
It will come after vacation.
Tomorrow matters. Regularization matter matters. The case is squarely covered also. Case of Jago and
After vacation.
tomorrow matters. I
They have said to 4 weeks. Yes.
Orders matter, Your Lordship. This Honorable Court has earlier stayed the order of suspension, and in spite of the order passed by this Honorable Court, the petitioner is not getting the salary, Your Lordship.
Not getting salary.
No, Your Lordship.
Anyway, after vacation it will come.
May I pray?
Next.
Before vacation, may I pray?
Next.
My Lordship, a retired government employee not getting his leave salary, pending leave salaries.
After it.
Yes, admission.
Yeah.
Present.
Fresh admission. After it.
Yes, it's identical matters.
Huh? Disposed of. Identical matters are disposed of.
Yes, ma'am.
Take that. Tomorrow.
My Lordship, a retired government employee not getting his provisional pensions.
After it.
matter relating to building regulation melons, challenging the order passed by the appellate authority melons. Let it come tomorrow melons.
What is the order?
Order is for that demolition of his building melons.
Demolition.
Yes, ma'am.
Tomorrow.
The petitioner was selected as the lecturer, Your Lordships. He had submitted all the certificates. No appointment was given. He was waiting. He had waited since 2022. The writ application is pending.
Immediately after.
Forward matter to the judgment of this Honorable Court. This is with regard to payment of revised scale of payment.
After vacation.
Fresh admission, petitioner is a lecturer, retired lecturer not getting pension. Fresh admission.
Fresh admission.
Yes, ma'am.
Yeah.
Another is identical matter, Your Lordship dispose of in university case. Identical matter can be disposed of.
Tomorrow. Yeah.
Your Lordship, weekly 124 item. Read petition number 25383 or 24, my lord.
Huh?
Double petition number 25383 24. This is matter, my lord. I have already purchased the plot through e-auction. And that still 2023, that matter is pending, my lord. That amount is already paid, and that amount is there, my lord. And now the amount that the land has been settled. Now they have to refund the amount, my lord.
After vacation we have that. Next.
Pardon, my lord. One matter in the supplementary in the Lordship's board. That is item number 53. 53. The part matter. 53. Yes. That is 6917/2025. Here my learned senior also appears for the petition. Part matter.
The material Lordship directed that bidders and
Removal
tenant.
from the stilt portion.
Removing steel portion, etc.
Yes.
Has he removed it?
Yes, already removed. Today I'm filing the compliance affidavit.
I've
In
got
course of
GPS
the-
photos of this morning
I
itself.
am also giving the photo.
And you will send somebody to.
Yes, that is
That office and other thing, he has just removed the angles, aluminum angles, the shutter, the shop, and the whatever there is around 600 or 400 some square feet. As it is intact, he has just removed the anglers.
Their whole idea is they don't want to accumulate the.
Let us.
Your Lordship has
We
said
can send
anybody.
some
Yes, sir.
youngster
That
to go there and report.
Yes,
So
sir.
that will be seen, na?
Yes.
Yes.
I made one.
You want time?
No.
Ready.
Well,
Item 50. No, that matter.
You are ready in the matter.
Yes, I am ready, madam.
Very well. We'll take that. Wait.
item 46, madam.
46.
In the weekly list. Look, that is a matter of transfer. I have been faced with 3 successive transfer with deputation orders. So notices have been issued, but now they're contemplating proceeding against me. Taken off my
Contempt.
It's a repetition. The successive transfer order I am challenging. With the 6 month period, there are many transfer orders. Even I have
First, we'll complete the admission matter.
yes. After that, shall I renew or maybe taken off?
Why memo? It's on the list now. We'll
Yes,
take up
yes,
that matter.
yes. Weekly list, yeah, that is item 46.
46.
Now-
Your opposite side is ready.
No.
State, memo. State
My
is
lord,
not whether state is ready with that. Tomorrow we'll have it.
Well,
Shift it to supplement.
okay.
Oh. Three transfers.
3 transfers. My lord, in the guise of deputation, now a proceeding is conducted.
Next.
Item 1. May I please?
Yes.
The petitioner was engaged as a domestic on 3/5/2008, my lord.
3/5/2008.
He prayed for regularization and filed writ application before this Hon'Ble Court. While writ application was pending, he was regularized with effect from 1st of March 2017.
Not with the initial date.
No, not from the initial date. He is to regular after completion of 6 years. This Hon'Ble Court directed that he is to be regularized after completion of 6 years, that is from 2014.
Covered by judgment.
Covered by judgment. Now, my lord, I have already issued notice in similar matter.
Take that. Issue notice. AGM Mr. Lenka is requested to accept notice for the OPs. Any private OP?
No, my lord.
All right. Next.
Item 2. May I please, your lordships?
Yes, sir.
My lordship, kindly see Annexure 1, page 11. The state government, my lord, the government of Orissa Food Supplies and Consumer Welfare Department has
They should receive your paddy.
Yes.
Which rule says that they are bound to receive your paddy?
My lord, that is Annexure 1, my lord, that is the guideline has been framed. Farmer registration for ensuing procurement of paddy.
There is a procurement policy.
Yes.
This matter is not your lordship's assignment. It
Not
is
in my assignment.
Court number 16.
Registry to.
No, it
Court
is
TPS matter and Paddy Control Act, that is court number 16.
it is not under Paddy Control Act. It is your lordship's assignment.
No,
The
the
matter-
order is, it comes under the.
No, that is not coming under Paddy. It is only.
The other judge will decide it. Why I should.
But it is not, your lordship may kindly see that the coordinate bench also will say that it will not be assigned to me. Well, that problem will come.
If it says, I will take up.
I had mentioned before the deputy registrar saying that you please list the matter. Whatever assignment after verification, it is listed before lordship. The matter which is not assigned in any other bench will be listed before lordship. Under that assignment, it is listed.
That the matter falls in the category of, in the residuary category. And therefore, this court has jurisdiction.
Yes.
First. Learned AGA, Mr. Lenka disputes this proposition, saying that matter has to go before the other bench in the light of decision of the apex court in the state of Rajasthan versus so and so. Must be registry to verify and take immediate decision as to where it should be posted. Okay.
Your lordship may say that the date of listing, but the paddy will be, your lordship knows that there is a farmers.
Day after tomorrow.
My diploma.
Immediately post this matter before the appropriate bench, roster bench, day after tomorrow.
My diploma.
Item 3. Well, the petitioner is a retired person, my lord.
Annual pension. Pension is not paid.
Not paid, my lord, due to pendency of the departmental proceeding.
But RACP is also issue.
RSCP and pay revision also.
Notice and the DG is requesting to accept notice.
Retired person, your lordship
All notice. Representation is given.
I will make a press representation, my lord. Before the opposition, but not
Take that.
lord.
But there is one representation you have already filed, long
No, my lord.
representation on December 24.
That is for finalization of the departmental proceeding, my lord. I'll make
That departmental proceedings are over now.
over, my lord.
He has to
I'll file a press representation, my lord. My lord. Before the opposition to.
again the
Petitioner has aired his grievance in that prayer, which has the following text. In the prayer call, which has the following text. Next paragraph. Learned counsel for the petitioner submits that there was some disciplinary proceedings pending against his client, and that the same having already been accomplished in his favor. In his favor.
Not my favor, my lord, but already finalized.
Having been accomplished, comma. All terminal benefits like pension, etc., have to be fixed on a regular basis and granted. First of all. Next paragraph. Learned AGA Mr. Lenka opposes the petition contending that to seek order of the kind, there should be demand and refusal, which is militantly absent in this case, and therefore petition be dismissed. First off, at this stage, learned counsel for the petitioner submits cap. He inclined to make an appropriate representation within 2 weeks, and the same may be directed to be considered by the jurisdictional OPs. But jurisdictional OP, whichever. First one. This is a happy thing to happen. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make appropriate representation with supportive material
within 2 weeks,
within 2 weeks. And if one is made, OP number 2 shall take a call on the same within an outer limit of 8 weeks in accordance with law. First, all contentions are kept open. No courts.
Item 4.
My lord, similar matter order has been passed by the Hon'Ble. I want the same judgment.
You want the same order? You copy to your friend also, man. Otherwise, how he will know? Have you changed the dates and other things?
No, my lord. Same date.
Identical.
Identical.
EWS.
My lord.
Where is your representation?
Representation annexure 2, my lord.
Annexure
11/8/2025. 8/8/2025. Postal date 11/8/2025.
Annexure 2 for the not this exact in his exact this program. Consider that's all.
Item 5.
But the petitioner is the retired assistant teacher of a government high school.
Yes,
Who retired on 31st July 2000.
pension, final pension is not given to you.
Provisional pension is
Given.
Annexure 7. Final pension has not been given.
Why?
That I don't know.
Why final pension is?
3 years and odd.
Have you made any representation?
No representation.
At least you make some representation so that they will be able to take a decision.
The Lordship will permit me to give it.
Petitioner has coined his prayer as a term. Next paragraph. When asked as to whether petitioner had made any representation for finalization of the pension and other terminal benefits, learned counsel very fairly submits. He is yet to make one. First one. Next paragraph. Learned DGA, Mr. Lenka appearing for the, kindly be seated, appearing for the OP submits that without demand and refusal, ordinarily writ of mandamus is not maintainable, subject to all just exceptions into which argued case of the petitioner does not fit. First, at this stage, learned counsel appearing for the petitioner seeks liberty to make an appropriate representation along with supportive material, so that the same would meet its fate at the hands of OP number
3.
3. Kindly sit down and answer. OP number 3. First up, this is appreciable. Next paragraph. In the above circumstances, petition is disposed of, reserving the liberty to the petitioner to make appropriate representation within 2 weeks. And if one is made, OP number 3 shall consider the same and inform result of such consideration to the petitioner within an outer limit of 8 weeks from today. First, all contentions are kept open to solicit your post. Yes,
Item 6.
no cause.
The petitioner has not received his salary since
November 2005.
my lord. That he has filed an OA. The OA has directed him to consider the reprisals. OA. He has not, the order of the OA has not been complied with. He again came to the High Court. During the time of the High Court file करछि that's a false statement under annexure 4. So that annexure has been challenged before
They have rejected your representation.
Yes. My lord, annexure
By order
4.
dated 18/12/24.
My lord.
Lakshmi Kanti Annexure 4, page 21. The details have been given.
Kindly be seated. Vasanto. Salary wrong. Salary not wrong. 1922 unauthorized absent. What inquiry was held to say that he was unauthorizedly absent? Take notice.
Yes.
Answer. Issue emergent notice. Mr. Lanka absent notice for the OPs. Any private party?
No.
No. Pause. Next.
Item 7.
May I take it, Lordship?
Yeah.
This is a second round litigation, Your Lordship. Earlier, the petitioner was sanctioned with the grade pay of 4,200, Your Lordship. That is under Annexure 5 at page 22, under RACP, Your Lordship. Subsequently, the Controller of Accounts passed the impugned order dated 6/9/2024, unilaterally revising my grade pay from 4,200 to 2,800, Your Lordship.
Downwardly revised.
Downwardly revised.
No notice was given to you.
No. I approached this honorable court. This honorable court directed to consider my case by way of representation. That is under Annexure.
That is rejected now.
That was rejected. The impugned order is under Annexure 9.
Saying what?
Now they are saying that relying upon one clarification that you are not entitled to get that benefit. That clarification is under Annexure 7. But it is contrary to the scheme, Your Lordship.
Clarification is contrary
Contrary to the scheme, Your Lordship.
Where is clarification?
Clarification is under Annexure 7, page 24, Your Lordship.
Clarification is issued by Additional Secretary to Government.
Yes.
That may
Yes.
make reference to clarify that as there is no cadre rules for employees to aid it by
Just
benefit may be allowed in their favor as defined in Annexure 1 of ORSP Rules 2009.
yes. Then I want to take Your Lordship to Annexure 2, page 16, Your Lordship. There is a clear guideline.
1/6.
Yes, Your Lordship. May I permitted to read?
Which ABCD, EFGH.
A1 is relevant, but prior to first para, I will permit to place first para 1.
Para 1.
The state government have implemented the RACP scheme for their employees in supersession of the SCP scheme under RACP rules, ORSP rules 2008 by resolution number such and such dated 6/2013.
3D upgradations will be available.
Yes.
10, 20,
And
30.
30. And now I am availing the 20. 20, it is a clear that I am entitled to get 4,200. But basing upon that clarification, now they have downgraded my grade pay.
Take notice.
Yes, sir.
Learned AG and Mr. Lenka is a notice on request for all OPs. Since matter lies in a narrow compass, call the same in last week of October 2025. Okay.
I have filed one IA, Lordship.
For stay of this
First stage. Yes, sir.
before that, an application is moved in IA number so supported by affidavit seeking stay of impugned order number 1675 dated 5/8/2025 at Annexure 9 passed by OP number 5. First one. Learned counsel for the petitioner vehemently draws attention of the court to the policy statement which provides for upgradation of the certain salary for emoluments on 10, 20 and 30 years service. First off, he points out that his case fits into the second component and therefore he was entitled to higher grade pay. Grade pay it is? Yes, grade pay. First off, he also tells that the clarification issued by the additional secretary to the government dated
7/7/2017.
7/7/2017 at Annexure
7.
Annexure 7 runs counter to the policy statement and therefore there is flaw in the impugned order. That too, the one which has been made unilateral. First off, there is a prima facie force in this submission. First, and next, in the above circumstances, the application having been favored, the impugned order is stayed till next date of hearing.
Grateful, Lordship.
You argued well. Yes.
Item 8.
Maybe. If the petitioners are the unemployed youths having the eligibility to be appointed as a teacher because they have their 10 graduates and also passed the teacher eligibility test. Now I are agreed by the government decision to fill up all the vacant posts by the retired teachers. Even if they don't have passed, they don't have the TET, the teacher eligibility test, they have not passed. But all these retired teachers will be filled up as 62 and 3. All 6,387 posts are going fill up by the retired teachers, so there is no recruitment for us. We are unemployed. This is my grievance.
This is it temporary measure or?
Yes, temporary. For 1 year, my lord, we will be over by that time. Because in the last occasion, in earlier writ petition, another writ petition by some other person similarly situated, they have come before this Hon'Ble Court with a similar prayer. Way back in 2021, because the attempt was made by the authorities. But only after issuing a notice, they have come down and issued an advertisement so that regular recruitment could have been made. But this year,
you are not taking regular recruitment?
First of all, Your Lordship will find from annexure page 62 that their appointment is only for till March 26, 5 to 6 months.
Within that, you will appoint those people.
No.
Regular recruitment you will do.
No, Your Lordship, I'll place Your Lordship. Your Lordship will find that 3 categories of employees, teachers are there. One in government school, then fully aided school, then block grant. I have today morning I got some instruction from the concerned DO, District Education Officer. For example, in the state district of Ganjam, there are 303 approximately posts lying vacant in government schools. After 24 advertisement, recruitment done, now it is 303. In fully aided school, 61 vacancy available in fully aided schools. And in block grant, 249. So government schools recruitment are being done through staff selection board. And aided school, fully aided schools recruitment are done through state selection board. That is, both are doing well. In the 24 also they have recruited. So far the block grant is concerned, after they came into the fold of a block grant, previously the managing committee were giving recruitment to the staff. Now when they came to the fold of block grant fold, so the government has not yet introduce any policy for their appointment, recruitment. So almost these guest teachers, most of the guest teachers are being recruited in block grant schools. Few for government school and affiliated school. That is the position. And Your Lordship will find from Annexure 4, my learned friend has realized the requisition has already been sent in 4/8/2025 for recruitment to initiate recruitment process.
What happened?
Only 4/8/25, a letter has been sent to the additional secretary school and mass because there is a procedure, man. That
Last recruitment was done when?
24.
2024, which month?
24, you have to let me time see that is advertised.
I have given.
Annexure
Annexure 2 I have given, man.
24.
Date 124.
8/1/24.
8/1/20. Mr. Lenka,
Yes.
I have one question to ask you. Take out that judgment of the Dharwad court, LIC of India versus so and so into 2023 or 2024. See, the youngsters will become age-barred.
Yes.
Where they should go.
Yes.
There is need, immediate need is there. Therefore, you are engaging the retired people. I can understand. But the date of retirement is known to everybody.
Yes.
The recruitment process is not periodically done.
Admittedly, in 24, recruitment process was initiated and the persons they have selected and got appointed.
Now, how many vacancies were notified in 2020?
1,024. 24.
All vacancies were notified. What the youths should do? All youngsters, they are committing suicide.
In 24 January, now we are in 25 September, man.
I understand. How many vacancies were there? How many vacancies you had notified?
That I have to.
That was that is there.
Then
2064 was the vacancy total.
2024 vacancies in the state.
2064.
62 in the whole state.
In that 24 advertisement. But now,
Total vacancies.
now my lord, they have stated 6,377.
One second. See, there are vacancies in the High Court. Out of 33, 20 judges are working. There are 40% vacancies in the police department. 40% vacancies. There are vacancies in the campuses, universities. Today, newspaper has reported Honorable
Yes.
Chief Justice having issued notice in the matter.
University.
What is this vacancy celebration? Why vacancies? You have money to spend for everything. Why? And the persons whom you are now appointing, they will not do their job free. For them, you have to make the payment. Why are you not appointing the youths? Where the youth should go?
The process has already
You
been
send
initiated.
youths to Mahanadi to jump into Mahanadi.
No,
That's all.
Your Lordship, Annexure 4 is clear that the process of recruitment has already been initiated.
How many are notified? How many? What I am just asking you.
Yes.
Selective appointment will not do. In every state, this is the problem. Why you are not periodically notifying the vacancies to the public at large? You should put in Cuttack Market the board saying that so many departments, so many vacancies are available. Within 1 year, so many people will retire. So many vacancies are going to accrue. So that whether government is doing its job or not, people will have information. Otherwise, where this youngster go?
But my answer to your Lordship's query is that government is doing its job.
No, that I am not sure.
Annexure 4. Annexure 4.
You are not answering what was the vacancy position.
1,800.
No, that is notified. In the whole state, it cannot be 1,800. The common sense tells that. No research is required for that. In whole of the state, how many vacancies in these schools? You can't do some in Ganjam, Anjam, etc. That is not the way. The entire vacancy position has to be notified to the public at large. You should tell the public, we have so many vacancies. So many vacancies are in next year because date of retirement is known to everybody.
Yes. But
That may not be.
at the same time, the learning and teaching of the students also.
Complete agreement.
That only the guest teachers are.
I'm in complete agreement. I will not come in the way of that. But why by the old people? Why not by the youngsters? You are taking note, the interest being looked after by appointing retired people is one thing.
Yes, it is clearly mentioned that tenure of the guest teacher will be up to March 26 or joining of new teachers, whichever is the end.
What is that you have done for new teacher? What are the total vacancies?
6,387 Annex 3 may kindly see. He's not reading that. Annex 3 page 62.
May I pay your lordship?
I am directed to convey the approval of the government for engagement of 6,387 number of retired teachers. These are the vacancies. 6,000 postmen.
And we'll issue notice, we'll counter to this.
Because students should not suffer is
Yes.
also important.
Yes.
But all old people you are bringing,
Also that your lordship may make some.
They are also not
and we'll-
qualified in terms of
we'll
research.
file our counter.
My lord.
Wishing
Now,
your lordship's good.
now the Supreme Court in that Anjuman Insaf case, my lord, held OTT is a mandatory.
That is a different thing. That is just
No, I am not, because we are also two keys, man. Avenue has been taken away from us for 1 year.
learned counsel for the petitioner vehemently submits that though vacancy position is very huge, no effective steps are being taken for filling the same on a normative basis, on a normative recruitment basis. And that is affecting the prospects of the youths who are otherwise eligible and qualified to be in the recruitment frame. First of all, he also points out that the teaching to be undertaken by the retired teachers would not serve justice to the community of the taught. First of all. Next paragraph. Learned counsel, can you get that judgment?
Yes.
No, it's the Dharwad judgment.
No, Harvard judgment, I just instantly.
We have same judgment. LIC Corporation also so and so, so and so. In Majar Malik, Apex Court said, you have seen that Majar Malik judgment.
Yes.
That Majar Malik judgment is 2000 so and so, Majar Malik Sultan versus 2022, IA 2022 it is, 2006 judgment. Honorable Supreme Court said,
Yes, sir.
all vacancies in the judicial wings should be appointed in Majar Malik.
That's why in every year.
Every year we undertake recruitment process. Why not teachers? I really do not understand. When I read today's newspaper, I really felt bad. What should happen to the children? And what should happen to the youth people? All youths aspiring for job. And comparatively, they will have much difficulty in a state like Orissa.
Newspaper article in respect of a university.
That is the case in respect of it is universal problem. Everywhere problem. It's universal problem.
Yes.
What is? Will not do justice to the community of the thought. First off, lastly, he adds that persons to be appointed as guest teachers do not have requisite qualification. First off. Next paragraph. Mr. Lenka, in his usual style, opposes the petition, submitting that the government has already issued a notification dated 1/8/2025 at Annex 3, and that the steps on war footing are being taken for making regular appointments to the vacancies. First off. However, he expresses some difficulty in giving the statistical data as to the vacancy position all over the state in the teachers category.
In different posts.
Different posts. Different posts. In education department.
Yes,
In education
secondary
department. And submits that.
Secondary education.
He would come out with full statistics and plan of action on the next date of hearing. First off. At the same time, he submits that engaging the guest teacher should not be halted in as much as halting would affect the interest of the students enormously. First off. This first. Next paragraph. Sure with this record section. In the above circumstances, the OPs are directed. Which OP?
All government, actually state is to do that.
The OP number
One is to do all these things. 1 and 2, my lord. Director secondary.
1 and 2
Oh, there are
are directed to do the following within 2 weeks. First, 1. What is the total vacancy position in all teaching institutions in the state? In the state. And number 2, what action is being taken for filling the vacancies availing in all sections of the Department of Education, higher education. Education only.
school and mass.
School and mass.
This
Not
is
only higher, other education also.
yes.
Yes, it should be given to me. Yes, all education.
Then he has to implement a opposition.
Not necessarily.
Your
State is a
state is
party. Education.
State school and mass is a party. School and mass education is a party, not higher education.
School and?
School and mass education is a party.
School and mass education. All right. Department of Higher Education. Higher Education. Okay.
School and mass and ad, both. There are 2 departments.
School and?
Mass education.
School and in the departments of higher education and the school and
Mass education.
mass education. Mass education. First off. Next paragraph. The information once furnished is likely to be directed to be published in leading newspapers. Leading newspapers.
Let us first,
So that
let us first produce it before.
we will tell them so that they will be on their feet. Otherwise, they will not know. Now, the only way to implement court orders is to tell the public at large
My lord.
what government is doing.
My lord, what we pray, my lord, let us place that vacancy position before your lordships. Then after whatever your lordship will direct.
Next part, I will direct
No,
that everything should be
everything.
published in all newspapers so that people should know whether to have the government or not.
Yes.
All right, only 2. Okay. Call this matter on 8 10. 8-10 we'll have this matter.
Longer time.
13-10. No, this what we are asking. What is the vacancy position?
Yes.
We are asking what is the step you are taking. That's all. Otherwise, I tell you, I'm very sorry to say, I should not say. I should not. I'll tell you at appropriate time. I feel bad. What should happen to the youngsters?
My lord, we understand, my lord, what your lordship wants to say.
What should happen to them? I'm not on this party, that party. All parties, very high parties, very high level parties, all parties.
Well, their
Very high
intention
level
is
parties.
other
I'm not on any party.
Their intention is
To
otherwise.
save my money.
Their
Because
intention is that if retired teachers are employed,
Less.
then they will
Less
not
amount.
claim for regularization.
You are not
If
absolutely.
youngsters are appointed,
No, that is not.
it is the intention.
This government is taking all.
That is the intention.
Recruitment process was never done, which was.
It was told earlier. Thing. Why such issues are not raised on the floor of the
Assembly.
assembly? Such a very important thing. The Churchill said, once I had told you, during World War I and World War II, the salaries of all teachers was enhanced, but the salaries of rest of the people, they were downwardly revised. For teachers, they enhanced the salary. And when the people after the Second World War wanted to felicitate Churchill, Winston Churchill, he said, don't felicitate me, felicitate our teachers, our schools. Why such issues are not being raised at all? The elephant has come here, that becomes the issue everywhere. But what is happening to our children, youngsters, that is not the concern. In every department, in university, in a school, in a kindergarten, in various departments.
Everywhere.
Since I am not in PIL jurisdiction, I cannot say more. But this is bad, I tell you. That is the reason why the state will not flourish. Especially the students. What should happen? And those who are qualified. You take them to that Mahanadi. Ask them to jump into that.
One of them has only 1 year left with him to get a government job.
And they become time barred.
Yes, but
Yes, Paul. Yes. No, this you should tell your government.
Yes, sir.
The anguish of the court should be conveyed to the government. Otherwise, I will publicize everything. I will not leave that way.
My lord, I am reminding you, your lordships, one incident. My learned friend was there and I was there before the director, higher education, in an appeal case. The director told to us that because we are issuing this circular, so that the youngsters who will get appointment on contractual basis or on temporary basis, they will not claim for regularization. In order to, my lord, prevent that, they are coming out with this type of circular.
hidden agenda.
That is the hidden agenda.
ମୁଁ ଯାଇ ଶୁଣିଲି ଆପଣ ଯାଇ କହୁଥିଲେ ଯେ କଣ୍ଟ୍ରାକ୍ଚୁଆଲ କରନ୍ତୁ ବୋଲି।
ନା ମୁଁ ରାଷ୍ଟ୍ର ପର୍ଯ୍ୟନ୍ତ ତାକୁ ମୁଁ ଥିଲି ପରା ସେଠି।
Next.
Item 9.
But this is a case, yesterday similar matter was there. Here, my lord, my application for inter-district transfer has been rejected relying upon that clause 2L, which is not applicable to state cadre teachers.
Take notice, let him take
Yes.
notice. Lenka is especially notice.
My lord, I'm giving
With WP number?
yes, that is WPC number 25563 of 2025.
Yeah. When it is posted?
After vacation, immediately after vacation.
Next.
Connected matters are also same.
Same.
Yes.
Item 10.
May please. In this case, I have a small prayer, my lord. Challenging the order of termination, I had already filed an appeal under section 10A of the Orissa Education Act.
Appeal to be disposed of.
Yes, ma'am. That's the only my
Appeal 11 of 2021.
21.
Pending petition.
The short grievance of the petitioner is against long pendency of his appeal number 11 of 2021 filed under section 24A.
Section 10A
10A
of the Orissa Education Act.
Of Orissa Education Act before the
Lana State Education Tribunal.
State Education Tribunal, Bhubaneswar.
Ma'am.
Bhubaneswar. First of all, Learned Counsel for the petitioner presses into service apex court decision in Rahul Shah versus so and so. Another judgment he said, which is that judgment?
Yes.
That is 2023.
And take that also in support of his contention that every appeal should be disposed of. That was an execution.
There is in case of execution.
Sites,
But here there is a provision under the rules
in support of
that cases have to be disposed of within 3 months.
within 3 months.
That is
There is such a provision in CPC also.
yes, yes.
Disposed of at the earliest point of time. Personally. Next paragraph. Mr. Lenka, Learned Counsel AG appearing for the OP submits that the tribunal has over workload
Yes.
And that would take the matters in a normative way, keeping in view the rule of seniority, and therefore litigants should not pressurize the tribunal personally. Having so contended, now he agrees to instruct the presiding officer of the tribunal to make all efforts to dispose of appeal in question within an outer limit of 6 months. Personal. This is appreciable. Next one. In the above observation, petition is disposed. Okay. Registry to send a copy of this petition to the presiding officer of the tribunal, to the registrar of the tribunal, State Education Tribunal, Bhubaneswar,
Secretary.
Secretary.
Okay, tribunal.
Fine, sir. Yes.
Item 11.
No, on behalf of PK Das, I am submitting, my lord. The opposite parties, the constituency amending committee violating their bylaw, my lord. For that reason, they filed a representation under Annex 2 series, as well as Annex 3, the under RTI Act. They have not complied with. So, Lordship directed to the opposite party number 2 to consider the representation Annex 2 series and to.
It's a private body.
No,
Purely private. State has nothing to do.
Nothing to do.
you know, as per the decision of this honorable court, my lord, if it is a private educational institution, my lord,
And this is
kindly see
What it says,
paragraph 7, my lord.
what it says. Give to other side also. They should know, na? Yes. What does it state?
Paragraph 7, my lord. My lord Justice B.L. Hansaria, in the case of Antarjami Ratha versus State of Odisha and others. Last two lines, my lord, last 2 lines. This would show that the private educational institution should be amenable to the jurisdiction of this honorable court to ground that they are performing their public duty.
Public duty.
For that reason, this retabling is maintainable. And,
You consider the representation.
Representation has been submitted to OP2. It's a private body.
yes.
We direct the OP number 2 to consider.
Yes. Consider
State has nothing to do.
only my small prayer will also permit my
This you should tell OP number 2
yes.
to do the needful. They are not completely out of your control. Though the extent of control of government may be very less because of apex court decision
That is
in
a committee, the society.
correct.
OP2 is a society. Shiksha Vikas Committee.
Whether it has taken recognition,
State, no.
state recognition is
No. Shiksha Vikas Committee is not recognized.
to take the recognition and the
Education Act,
position.
permission and also
See, some element of control is there. If you do not do, we will revoke your permission. NOC.
Yes.
You can threaten them.
No, they have to take certificate of recognition under the Compulsory Education Act and the rules.
No, it is not a school.
Saraswati Shiksha Shiksha Kendra, my lord.
Shiksha Vikas Committee controls all the Saraswati schools. So direction, the petitioner has sought for a direction to the Shiksha Vikas Committee, not the school. The Lakshmi Dishwar.
Petitioner has scripted his prayer as under. First, the essential grievance of the petitioner is as to non-consideration of a slew of representations in Annexure 2 series. First, counsel for the petitioner submits that the OP number 2
Yes,
is also amenable to writ jurisdiction of this court in the light of a division bench decision of a single judge, a coordinate bench decision of this court in Antaryami Rath versus State of Orissa. What is the report?
Reported 1992 IILLJ.
Write down.
That is
Is there?
No, it's not there.
At least 370 RI.
Right outside. Next paragraph. Learned AG appearing for the OP number 1. 1 and
Only one.
1. Submits that. OP number 2 is not under the control of OP number 1, and therefore it is helpless. First off, at this point, learned counsel for the petitioner points out that certain NOCs, no objections, certain NOCs and permissions are accorded to OP number 2 for founding and running the educational institutions, and that itself would give some measure of control over the institutions and the bodies that run those institutions. First one, be that as it may. Next paragraph. Justice of the case warrants that the subject representation should be considered by OP number 2 in accordance with law after giving opportunity to all the stakeholders. First off. Next paragraph. Stakeholder, within an outer limit of 3 months. First. Next paragraph. Registry to send. Petition is disposed of. Registry to send a copy of this order to OP number 2 to 6 by speed post immediately.
No. If Lordship permits a small prayer, my lord. Till then, my Lordship disposal of the representation under Annex 2 series, my lord, restraint to the opposite under 6 to operation of the managing committee and activities.
Yes. Yes.
Item 12.
May I please, Lordships?
Yes.
Lordships, I have filed this writ petition for the rehabilitations of.
To give appointment under rehabilitation.
Yes, Your Lordship. I have filed an application as well, but that was not considered after the death of my father, that is in 2019. And on 21/2020, I have filed an application for the rehabilitation, but that was not taken into considerations till yet.
When death in harness occurred?
It was, Lordships, in
2019.
Who was he?
Is my father.
Father. Your client is married?
No.
Not married?
No.
Dependent?
Yes.
What is her age?
No, that's a boy, the son. Yes.
And your representation is dated?
21/2020. 21/1/2020.
2021.
21 January 2020.
Annexure?
That's annexure 5, Lordships.
What was the father?
That is not a representation, my lord. That is the application.
That's an application.
That's what application.
Not
What was the father?
He was appointed as a peon, Your Lordships. Peon, yes, peon in the school.
You consider that because of export Gayatri Devi? Yes. Next paragraph. Right now. Petitioner, an aspirant for appointment on compassionate ground, he is grieving before this court that his application dated 21 January 2020, that annexure 5 is under the state rehabilitation assistance scheme is kept pending indefinitely. First off, counsel for the petition, kindly be seated, sister. In support of petition, learned counsel presses into service a decision of this court in Ritanjali Giri at Elias Pal versus State of Odisha. The prayer column it is there. 2016, 1 ILR cut
1162. 62. First of all. He also draws attention of the court to the memo number 16029 dated 1/8/2019 issued by government through the Department of School and Mass Education. Kindly be seated, Mr. Lenka. Yes. First, next paragraph. Learned DGA, Mr. Lenka, on request appearing for the OP, submits that he would instruct the jurisdictional OP to look into the subject application of the petitioner on a war footing, and that he understands the difficulty of a family which loses the breadwinner. First, this is really appreciable. Next paragraph. In the above circumstances, petition is disposed of, fixing a period of 8 weeks for taking a call on the subject application and to inform result of such consideration to the petitioner. First, all contentions of the parties are kept open. Next paragraph. It is open to solicit any information, document from the side of petitioner as are required for due consideration of the subject application. However, in that case, no delay shall be proved. No.
Item 13.
Yeah. Yes. Pass over.
Item 14. Item 14, my lord, that
Now, both you have become friends yesterday. Okay. We should not personalize our things. We are only agents in the hands of the cosmos. Whatever dictation comes from the cosmos, whether you call it God, whatever, we should speak. And we should not quarrel at all. Really? Yes.
my friend.
Yes.
Petitioner is a retired clerk, my lord. He is retired 2024. So benefits are given 2015, my lord. After retirement, they will notice to recover all the amounts, my lord.
Retired on which date?
2024, my lord. 2024, my lord.
2024.
Again.
Which date? No retirement date is given. That's essential, na? Because of Rafiq Masi.
Rafiq Masi. Yellow two one password mal add notice out. In similar case, you also issue notice once.
You should notice. I don't know someone AGA to accept notice.
Sessions.
Any entry matter is granted?
Yes, ma'am. Also granted, not to recover, ma'am.
Council submits that
14 and 20, ma'am. Both same.
the facts of this case are substantially similar to the one in WP number so and so, wherein protection against recovery has been afforded, and therefore the same reprieve has to be extended to his client.
And except 6 and 7, ma'am.
There is force in this submission. Next, in the above circumstances, interim order as had been granted in WP number so and so is issued here also. First, call this WP along with all this matter along with WP number. So it's a sign. Okay.
Item 15 and 20 also, ma'am.
20 also same.
Again.
So you have become expert in recovery, stay, and yes.
No, my lord, exist. Casual thing.
May I please, Your Lordship?
Yes.
The petitioner is a junior clerk and appointed on the rehabilitation assistance scheme, madam, in the year 97, madam.
Arrears of salary not given to you.
Yes, my lord. Even
To
though
give representation.
bill has been submitted, Your Lordship, for a moment, kindly have a page 34. Page 34, Annexure 10, on 19/12/2015. Bill has been submitted. My name is serial number 2, Khageshwar Amanta.
They are not given.
Not given. Thereafter, government again issued reminder in 19, page 35, on 4/10/19. But till then, they have not given. And coordinate bench has already decided one matter, that is Annex 15, page 43.
Annex 15, page 43.
But the direction has been issued to the government to release the salary within 3 months, madam. And I am in the same footing. I have already repented under Annex 16, page 52, madam.
52.
Madam.
In December 2015, they had prepared the bill.
Madam.
But 25 years has not happened.
No.
10 years not happened, na?
On 4/10/19. 15, they have prepared the bill.
Yes, Mr. G. How many years you need for making the payment?
No, here, my lord, here is a case. He was appointed under rehabilitation assistance scheme, but under NFE, non-formal facilitator.
No, madam.
Thereafter, my lord, after abolition of the scheme, my lord, last come, first go, on the basis of last come, first go, he was terminated. Because he was terminated on that date, my lord, subsequently thereafter, some people approached the tribunal. The tribunal directed to implement the order. This matter was before your lordship, and it was again, your lordship confirmed the order of the tribunal. Again, it was before the Supreme Court. And thereafter, the Honorable Supreme Court remanded back the matter to your lordships. Your lordships have decided the matter in case of Santosh Kumar Hota versus State of Odisha. Saying, allowing the petitioner, confirming the order of the tribunal. Thereafter, the petitioners, they got the benefit for the period that from 2001 to 2003, that period, my lord.
2001 to 2003. But his cases?
One for 2001.
He is also playing
for 2003.
He is also praying for that period's salary. If your lordship will say that that period salary will be counted towards the seniority, problem can be solved.
Is he still in service?
Yes, they are continuing on.
But what about the salary?
Salary he has not worked for that period.
During that period, he has not.
They were all terminated.
If they were terminated.
Yes.
Suppose if that period is given, you will be happy.
That period has to be given because I was not appointed under the scheme. I was appointed.
He says yes.
My service book, your lordship, can have a glance.
I'm saying
that I was appointed under
rehabilitation assistant.
He is saying, Mr. G is saying very fairly that that period during 2001 and 2003 would be treated as your service period.
Yes.
That will be sufficient to you. Perfect. Petitioner has structured his prayer as under. Next paragraph. Kindly be seated. Learned counsel appearing for the petitioner. Mr. G, kindly be seated. Draws attention of the court to petitioner's representation dated 16/12/2024, wherein he has made the following request. See that page number 54, 55. Next paragraph. Learned counsel submits that regardless of the representation, his client would be satisfied if the period between 1/4/2001 and 4/8/2003 is reckoned for the purpose of service notionally. First, next paragraph. One second. In support of this contention, he presses into service the decision in which is that, brother?
Annex 15. Page 43.
Right from the details section. Next paragraph. Learned AGA Mr. G appearing for the OPs, although initially opposed the petition, now in all fairness submits that no monetary benefits can be granted to the petitioner for the said period, and that petitioner's request for reckoning the subject period as service
is acceptable in the light of decision.
In that decision, already direction payment has been made, madam. In
But
that,
now you said that you will accept this one, na?
no, that payment has to be made, madam. The coordinate base has already decided. For a moment, kindly have a glance. That
You agree to that?
that your lordship pays 50 since this court find that the petitioner is
What do you recommend? Decision. In the light of decision, Supra. First off, learned counsel for the petitioner insists that in the said decision there is a direction to make payment of certain amount
within 3 months. Yes.
within 3 months, and therefore the same benefit has to be accorded to his client also.
Okay.
First off. Next one. In the above circumstances, petition is disposed of, directing OP numbers. 1. To consider petitioner's representation dated, you have seen that,
16 to 20.
24, in the light of
I accept 50.
the subject decision at a copy whereof awaits at Annexure 15 within a period of 8 weeks. First off, all contentions are kept out. Cost vacancy. Yes.
Item 16.
May I please?
Yes.
But the petitioner is a trained graduate teacher. But he was transferred under Annexure 2 at page 70 from Badosimulia Girls High School to Bahuband Ashram School. Your Lordship may kindly come to page 70. My Lord may kindly come to Annexure 2 at page 17.
Yeah.
Serial number 17. Ranjan Kumar Naik, the present petitioner.
Yeah.
He was transferred from Badosimulia Girls High School to Bahubanda Ashram School. And now your Lordship may kindly see serial number 18. One Pratibha Manjari Parida, she was transferred from Bahubanda Ashram School to Bahubanda Girls High School in the same place.
Yeah.
And distance is only 300 meters from her former school to present school. Well, at pursuant to this order, dated 13/6/2025, I was relieved on 21/6/2025. Your Lordship may kindly see Annexure 3 at page 18. From my former school, I was relieved on 21/6/2025. And Pratibha Manjari Parida was also relieved on 21/6/2025, that is under Annexure 4.
Yes.
My Lord, thereafter I submitted my joining report in the new school, in my new place of posting, that on 21/6/2025.
Same day.
Annexure 5.
Yes.
And since 21/6/2025, I have been continuing in my new place of posting. My Lord, Pratibha Manjari Parida, she filed a writ petition in this honorable court, and this honorable court, I have quoted that order. Your Lordship may kindly come to page 7 of the writ petition. This honorable court passed
Your monthly salary to be released.
Yes, my Lord, this honorable court passed an interim order of status quo. In her case, that case is pending. And that order was passed on 25/6/2025. Prior to that date, I was relieved. I had already joined. Although I have been discharging my duties in my new place of posting, my monthly salary from June 2025 has not yet been released. And since it is a residential school and 242 students are residing in the hostel, my Lord, I have already incurred expenditure of around a sum of rupees 6 lakhs, approximately.
From your pocket?
From my pocket.
Why?
My Lord, because of the pendency of that writ petition, my Lord, the government grant has not been sanctioned, although it is a government school.
That's right. You should have told the government, children are starving.
Yes. My Lord, I have already told. I have made a representation to the collector. I have made a representation to the district welfare officer. They are saying that since that writ petition is pending, and an interim order has been passed.
We'll call this matter along with that.
Yes, yes. My lord, I have also filed an application for vacation of interim order in that case. That matter was before your lordships yesterday, and your lordship posted that matter to 14/10/2025.
We'll have this matter also.
That is WPC number 17127 of 2025.
No. Issue emergent notice. Learned AGA Mr. G accepts notice for the OPs. Private respondent.
My lord, I have not implicated her as a opposite party in this case.
Okay. Call this matter along with WP number. So
17127 of 2025.
Next.
On 14/10/2025.
Date will not put because whatever date there it is saying.
Yes.
Come along.
Yes, yes.
Item 17.
I know. The order of the tribunal has not yet been complied with.
They are not compliant with the order.
My lord.
Will the High Court implement the order passed by the tribunal?
Yes, because the tribunal is not in existence. Now, where is
The order
what it says?
Was a year back. Order was passed in long back, my lord.
the order was passed on 31/1/2020.
11. 31/1/2011.
What was the order?
That the area salary will be paid to the petitioner.
No, it is.
No, seniority and
Yes, yes.
notional promotion. Huh?
My lord, lordship.
Seniority and notional promotion.
Yes. The fixation. Hence, after hearing all parties, it is hereby directed that the seniority of the applicant in primary school cadre be computed with effect from the date of his initial joining, as he was not allowed any option before posting under IEDC scheme. While his junior in the select list were posted as a regular primary school teachers. The applicant claims to have represented for transfer, which has been dealt with in memo number so at annexure 2, which the respondents claim has not been received by them. Given this specious argument, the adequate number of vacancies of primary school teachers were not available, hence the applicant was observed in IEDC scheme is not a good enough excuse, and other below the select list have been observed as primary school teachers. Hence the claim of the applicant for absorption in primary school teachers.
Said it hereby directed. Applicant claims to have represented for transfer has been
Now-
so.
Now in some matters are before your lordships also.
These matters.
Some of these
But
matters.
he has obtained an order in his favor.
Yes.
Although he slept over so many years, all right. But interest and other things will not be payable. But that amount, how can the state, as the model employer, withhold those things? That exercise has to be done.
My lord, ORSP 89, 98, are they entitled to while working in a scheme?
No, you
Are
did
the-
not challenge this order.
That order.
That
having
order
the-
has attained finality.
My lordship, I am to see whether it is a single order, or it is a single order.
Single order.
A batch of cases where are also before your lordships.
That's all right. But you have not challenged this order. Just look into it.
My lord,
Just
I will take care of it.
AGA is requested to accept notice for the OPs. Call this matter on 24/10. 24/10.
Yes.
Why you did not come to court so many years?
He has come to me nearly.
Coming to you is appreciable. Okay. Item 18.
Item number 18, your lordship. The petitioner is claiming pensionary and retirement benefits.
Sharat Chandra Parida.
Yes, sir.
Harassment Chandra Parida, that Hemant Chotray, 26.
Covered by judgment.
Yes, your lordship.
Similar orders we have made.
Similar orders were passed. Your lordship also notice was issued after vacation.
We have
They are-
notice in matters.
In some cases, after vacation, yeah.
Issue emergent notice. Mr. G accept notice for all OPs. Governing body 6, sir.
6 we shall not receive.
Emergent notice to OP6. OP6. First one. Post in the last week of October, along with connected matters. Do you have connected matters number?
No, Your Lordship, one.
Do you have connected matters? That is all.
Item 19.
On behalf of Mr. Pramod Das, I want to commit that this matter pertains to the recovery of RSP benefits from the petitioner after his retirement.
After his retirement, similar matters we have granted stay.
Yes.
It is that matter. Issue emergent notice. Mr. G accepts notice for OP number so and so. An application is filed seeking interim protection from recovery.
No, they have already recovered the amount.
Recovered.
Already recovered the amount.
Then let it come after hearing, let him see, and then we will look into it.
Similar matter has been
Discord asked. Kindly look in. Show it to your brother.
It's directed to refund the entire money.
Entire money I have directed to refund, but no interest for the same period.
Your Lordship, 1%.
If only if delay is caused, not otherwise.
Yes.
So in terms of that, we will dispose of, or you want to file objection?
Objection. Lordship, disposal.
The subject matter, the petitioner has scripted his prayer as under. Next paragraph. Learned counsel for the petitioner submits, and learned AGA on request appearing for the OPs does not much dispute that the subject matter of this petition is substantially similar to the one in WP number
3605.
So between so discord of by discord. While order dated first. The operative portion of the order reads as under. Next paragraph. In the above circumstances, this petition is also allowed, any clashing of the orders.
No, it is not there. No.
A writ of mandamus issues to OP numbers.
4.
OPs
2 and 4.
2 and 4.
Yes, Your Lordship.
OP numbers 1, 2, and 3. 1, 2, OP numbers, OPs. To refund or cost to be refunded, all the amount recovered from the petitioner within a period of 3 months with no interest. First. However, if delay is caused, the same shall carry interest at the rate of 1% per month, which may be recovered from the hearing officials. No costs. Yes.
Item 21.
Lordship, connected matters are also the same.
Which is that?
26326 of 2025. 19. Item number 19.
19?
Yes, Your Lordship.
Same?
Yes.
So not separate. No? Submatter is also there.
Yes.
18 and 19 same?
No, 19.
19 same.
19 is submit.
Okay. Same order.
Item 21 regarding the MSP matter, my lord, the petitioner retired. MSP matter, my lord. Similar matter has already disposed of.
21 is
Yes, ma'am.
what is that? Just show that.
The petitioner is retired headmaster. After that, he is not getting to benefit for MSCP.
Same order.
My lord.
Yeah.
Item 22.
22, my lord.
Yeah.
My grievance on the Annexure 7 is pending before the OP number 3 for release of certain scale of base, my lord, which has not been extended to the petitioner.
Your representation annexure 7?
7, my lord. That is may be pending before the OP number 4.
Take now. Petitioner in his representation dated 21/9/2024, a copy whereof avails at Annexure 7, has requested the Superintendent of Sanskrit Studies, Odisha, Puri, for grant of which scale of pay it is?
The scale of pay of rupees 1,400 to 2,300, my lord.
1,400 to
2,300
2,300.
for the period from 1,694 to in the prayer I have put it.
600 GP 4,200. Yes. Just like recall that one. Petitioner is knocking at the doors of Writ Court with the following text of prayer. Sorry. Next. Learned counsel for the petitioner submits that his client has already made a representation dated 21/9/2024 to the OP number 4, and that the same remains unconsidered till date. And further that there is no hope that the same will be considered before long. First off, counsel submits that the intervention of this court is eminently warranted. Next paragraph. Learned AGA appearing for the OP.
It's a stale claim.
Huh?
It's my objection. It's a stale claim.
Still claim. Opposes the petition, contending that the petitioner has raised a stale claim and therefore no relief can be granted to a person who approaches the court after broking delay. Having so contended, now he agrees to instruct OP number 4 to look into the grievance of the petitioner in accordance with law, if all contentions are kept open, including the staleness of the claim. In the above circumstances, petition is disposed of. 8 weeks. Open to solicit.
Item number 23 is similar to 21.
23 is 21.
Yes. There's also Mahapatra that.
Take that. All different dates. Only one day.
Yes.
All one day.
No.
Different dates it have to be.
No, different day.
Huh?
Different. All the matters will cover in that.
But in this only.
Yes, sir.
No dates are mentioned.
Common judge.
ସେଇଟା ଯୋଉଟା ଦେଲେ ଆଗରୁ ସେ ବେହେରା ସେଇଟା ବି ସମାନ
Yes. All there. Disposed of. This name to be shown. Huh?
Item 24.
Yes, sir.
Lord, please 19, my lord, kindly see.
19.
My lord, I was regularized. Services was regularized. I have given a typed copy, my lord. Appointed initially ad hoc, then regularized on 24/99.
Yes.
With effect from the initial date of appointment, 3/8/98. Then, my lord, may kindly turn to page 25, please. Page 25, I was taken in as the non-graduate. There was an approved vacancy, non-graduate librarian of the college. This followed by page 26, my lord, at annexure 8.
Let him take notice.
My lord, I have retired. Now, question is, because of the pendency of annexure 11, I might have a very short prayer, my lord, because it has been stalled because of a confusion, because a litigation was continuing from this Honorable Court to Honorable Supreme Court concerning 2 other persons over 1 post. For that, they have not acted at all, my lord. That is my specific pleading.
If your representation dated 6/11/23 is considered.
No, my lord. That is yet to be considered.
No, if that is considered, direction is given for consideration, will you be satisfied?
Yes, ma'am. Because it doesn't, actually, nothing stands on my way. No dispute.
This is of year 23.
Let him file another fresh so that.
This also will mention.
My lord.
But then in addition to that, let him give similar representation. The short grievance of the petitioner is as to non-consideration of the representation dated 6/11/2023. Which is self-explanatory. Learned counsel for the petitioner submits that when a citizen makes a representation of the kind, it is the duty of jurisdictional OPs to take a call on that and inform result of such considerations to the citizen concerned. First off, he quotes Article 350 of the Constitution of India as has been interpreted by various high courts in the country. Next paragraph. Learned AGA, Mr. BEHERA, appearing for the OPs, opposes the petition, saying that no proof is produced having given the representation of the kind. First off, however, in all fairness, he submits that if petitioner finds one more representation, he would instruct OP number 2 to look into the grievance of the petitioner in a time-bound way and in accordance with law, should all contentions of the parties be kept open. First, with this proposition, counsel for the petitioner is graciously agreeable. First off, next point, in the above circumstances, petition is disposed of, reserving liberty to petitioner to make appropriate representation within 2 weeks. And if one is made, a call shall be taken by OP number 2 thereon within an outer limit of 8 weeks. I am to inform petitioner the result of consideration in writing. First off, all contentions of the parties are kept open. Now, no course. It is open to solicit.
Item 25.
Yes.
And this is a matter related to appointment of a rehabilitation assistance scheme. The Annex 3, the application, which is forwarded by the headmaster to the district education officer, that is pending till today, and your lordship coordinate bench also passed the order basing upon the 2020 rules. Your lordship kindly, I have
consider this.
Yes, I have corrected the copy, and your lordship kindly visualize me. They have directed to consider Annex 3 series, that is my application as well as all documents.
Identical.
Yes, ma'am.
Yes, Mr.
I have already solved my copy, ma'am.
Yes.
Let's hear. My only grievance is non-consideration by reference. The MSMED Act says that my reference has to be considered within 3 months. 1 year, 3 months have gone by. And my matter is not once one listed, defense has been filed, nothing is happening. I have declared Annexure 5 may be seen, my lords. I request them that please take up my matters. 11 matters, my lords.
They are not doing that.
No, my lords. My only prayer, my lords, a short period may be fixed for them to finalize my only this matter. My lords, I'm not on 11. There are more.
I will issue emergent notice so that let them come here. We will ask them.
Yes, government will. My lords, my learned senior will represent opposite party number 1. It is actually the grievance against opposite party number 1.
2 is also there, na?
2 is the my defendant. Here, because he will appear and say there. He is not objecting to that. My listing is not happening. This letter. That is my only grievance. Not else I don't have anything to stand on.
My lord, dispute between two private parties.
It is to be taken and adjudicated.
Yes.
The lordship may direct to dispose of expeditious.
There, what is the pressure and other things we do not know.
My lord.
At least once they have to take.
My lord.
Once they have to take and say, we do like this, we do that, so that he will be able to answer his claim.
Yes.
If he keeps it pending throughout, how to...
Even Act says, my lord, should be disposed within 90 days.
There's almost around 700 petitions are pending. Mine only 35 to 40 petitions are pending in that court. Nothing is happening.
So who is the presiding officer?
He's an officer of the IS officer of the government. He's been appointed as chairman, ex-officer chairman. And
Director DTT.
also he's a director of fisheries. So he's busy in fisheries and not able to devote his time.
Take down. Petitioner has an innocuous prayer which he has created as under. Next slide. Learned counsel for the petitioner submits that the MSME Act 2006,
Section 18, subsection 5.
2006, wide section 18(6) prescribes a period of 3 months, ideal period of 3 months for disposal of disputes of the kind, and that till date, not even once this matter had come before on the board.
Once, only once.
And that the matter had come before the board only once, and thereafter not even a page is turned. First half. Next paragraph. Learned counsel for the petitioner is right in telling that notice to OP number 2 be dispensed with, so that he would be given full opportunity of participation when the matter is taken up by OP number 1. First one. Learned AGA appearing BEHERA appearing for the OP number 1 submits that matters of the kind should be heard and disposed of within the short period is due. First off. However, he submits, he adds, because of higher pendency, the ideal period prescribed by law is not adhered to may be true. First one, he assures the court that he would instruct the presiding officer of the that is OP number 1 to expeditiously dispose of the dispute in question within an outer limit of 6 months.
Much
6 months from the date a copy of this order is presented on the table of OP number 1. First one, this is appreciable, and this is agreeable by counsel for the petitioner also. First one, ordered accordingly, petition is disposed of. Registry to send a copy of this order to OP number 2 by speed post immediately. All contentions are kept.
That's only one thing. That 18(5), 18 subsection 5, Pilots has declared
18(6) I say.
Yes.
18(5).
Much of this.
Thank you.
Much of this.
Item 27.
Yes.
Item 27.
What is this 27? IA is also filed. You that. Emergent notice.
My lord, 6 is a private party. 5 and 6.
Emergent notice 2, 5 and 6. AGA for 1 to 4. 1 to 4. One post here sought for keeping vacant.
My lords, no instruction, I do not know.
Item 28.
May I please?
Yes.
My lord, may kindly take page 21. This was the order by
To revise the gradation list.
Yes. Now here what happened, the petitioner along with others, all of them were appointed or engaged on 30th of March 2011. Thereafter, on the same day, they submitted their joining report. But while releasing the remuneration, it was released with effect from 2nd of April 2011. That's why they made representation before the authority, and the DPC, the appointing authority, considering the same, verifying that they joined on 30th of March, so the remuneration for that period was released, and subsequently they were treated to be appointed on 30th of March 2011. On that basis, they were given promotion. Subsequently, on the next grade of promotion, while preparing the gradation list, it was the date of initial entry has been changed from 30th March to 2nd of April. 2/4. Therefore, the petitioner along with others, they came before this Hon'Ble Court, challenging with that.
They take notice.
Yes. And what they have done in the meantime, they have also stopped our increment. My submission is, whatever as per them, the increment should be granted.
Let us see. A short point is involved.
Yes, Your Lord.
Covered by judgment. Also.
Yes.
Issue emergent notice. Mr. E.G. is requested to accept notice for all office.
Yes, Lord.
Calling the last week of October 2025. But give him copy.
Yes, sir.
Item 29.
But another thing, my Lord, I filed an IA. Let them grant the increments as per their calculation.
No, when matter is pending. Suppose if we
last 7 years we are not granting increments.
Let us.
7 years, my Lord.
Anyway, in October it is coming, na?
Other matters are there. I'm giving them. Yes.
Along with the WP number, so it's.
All those matters notice be issued, because all the fresh matters I had given memo yesterday, but only one this matter had come.
Bring that ask them to post all those matters as special address. Okay? And issue notice. Yes, call along with each other.
Item 29.
The petitioner who is the widow of a deceased government employee, rehabilitation assistance scheme sought for an appointment. And the petitioner's husband, who was working as a junior clerk since 27th, 1991. And he died on 4/3/2017.
Yes.
And your lordship delivered several judgments. That's the Ritanjali Giri and the circular, and this Hon'Ble Court another judgment.
What they say?
They say they have to give an appointment because added school, added college.
To them also, the compassionate appointment scheme is applicable.
Yes. And the petitioner daughter who is unmarried and got major in 2023, and unmarried a son, minor son, who get major 2025. And the petitioner claiming that her unmarried daughter, who is now major in 2023 and +2 passed, she should be given appointment under the rehabilitation assistance scheme.
But who is petitioner is not the applicant?
No.
Mother of the applicant.
So
petitioner should come. Suppose petitioner says, I am not interested. Mother is saying that the daughter should be given.
Yes.
But suppose doctor says, no, I am not interested.
The doctor is interested.
No, you are saying that. We don't know.
No. Mother says that doctor should be given appointment, and doctor is also agreeable to that aspect.
Right to appointment on compassionate ground avails to individual. That individual should come before the court. Individual's mother, grandmother, great-grandmother, if they come, how we should give their leave? Or at least she should be made a party.
Because I have given the documents of the daughter.
We do not know whether daughter would be agreeable to marry XYZ. Mother is saying she should marry, but she may say no.
Yes. She is not married, and she is dependent, and she is ready to take.
But you have to make her a party.
Otherwise, she will file an affidavit that I will take care of all the family members, and I will be ready to get this appointment. She will file an affidavit.
You take notice for the OPs
1 and 2.
1 and 2. A petitioner to implead daughter. Srimati.
Rajanandini Oja.
Srimati so and so as OP number 5. First up. 5.
My lords, all the major legal heirs should be made parties, because son
May I have objection?
How many children this lady has?
One son, one daughter.
They implemented both of them. Petitioner is directed to array both the son and daughter of the petitioner as OP numbers 5 and 6. Immediately. First time. Yes, you array them.
Yes.
Issue notice 124 OP AGA 5 and 6 emergent notice. You amend that. See what is the process? Amendment has to take place. Online amendment.
This
Just do that.
My lords, notice may go to 3 and 4 also because
The college. 1 and 2 you will be appearing.
my lord.
1 and 2 AGA to rest of the people emergent notice. Okay.
Item 30.
May I please, Lordship? This matter, my lord, senior advocate from Delhi will be arguing.
Yeah.
He has some difficulty. He has prayed for after lunch. If your Lordship please accommodate.
Possible.
My lord, after lunch, my lord, first case.
Very.
Item 31.
Interim neighbor. Notice.
Yes, sir.
What is supposed to do? I'm sorry. May I play one more thing, my lord? The prayer of the petitioner, my lord, will suffice because today in the morning we came to know that certain development has taken place. The management of the school was taken over by the government. Now they have proposed to return it back. This letter, if I can hand it over to my learned senior, there's no interim order. I'm not praying for any interim order. Let him take instruction. Let it come after vacation.
Issue emergent notice.
Now they have decided to give me back the management.
BEHERA accepts notice for OP numbers.
My lord,
All OPs.
No, my lord.
Yes. Yes, all of this. Collector is a party and district social security officer.
All, my lord.
Yeah.
There's a letter, my
Yeah,
lord,
vacation.
which I'm relying, my lord. This development has taken place after filing of the application. So we couldn't bring it on it.
Counsel for the petitioner has placed on record a
Letter dated 9/9/2025.
letter dated 9/9/2025 issued by additional secretary to government to
My lord, district social security officer. OP3.
OP number 3, which arguably addresses
My lord. Fourth line.
the grievance raised in the petition. Then why you to keep it pending?
No,
We'll direct him to
no.
implement the letter.
Lordship may say so, my lord.
That's all. If it is true,
My lords,
you are certain.
Yes,
my lords,
to suffice, my lord.
there are serious allegations against me.
Yes,
There's one letter.
That will be considered.
Call immediately after vacation.
Grateful.
Call.
Item 31.
One minute, some very sensitive matter.
Yes.
The 3 petitioners are the working with the lecturer, lady person, lady lecturers. They made allegations against the principal for sexual harassment in several ways. That is what it was. Government required an inquiry by the collector. Inquiry was made. Thereafter, government took a decision to transfer the principal and initiate necessary departmental proceeding. That
Transferring him so that he will do that the same in other
anyway, at least must be controlled. But here in this case, must because kind of glass to an extra 4, page 78.
Yes.
This is the order.
Has been transferred on administrative ground. He may not be assigned the charge of principal till he is retired.
That is the thing.
Are there no schools where there are no women? Women, like all women police station,
Yes.
all men police station, all men colleges.
So slowly and gradually things will happen in that way. Of course. But the very pertinent is the memo. That memo 42076. The president, the copy forward to the president.
Yeah, I read that.
They are not departmental proceeding, all this. Now what happened? The principal have come and challenged it before the Hon'Ble High Court.
This one. In WP? In which WP?
Page 97.
It is page 82. WP is in 82.
It is pending.
No. That has been disposed of. They are minor the pinches. It is minors that they got that notice was issued. Thereafter, pendency of that, the government advocate have come up with a plea that this order has been cancelled and the relief order issued has been recalled and he is continuing as the principal. But that relying upon that, my lords, Honorable High Court disposed of this. Subsequently, what happened? The managing committee, my lord, the president, corrected that it is not a cancellation of the transfer order, it is a cancellation of the relief order. Because of the fact that by the time the notice was issued, the relief order was issued, it was recalled. So that modification was there. And this was brought to the notice of the Honorable Court, then kind of a glass to this final order. That modification and final order, that is at page 96. That's paragraph 6. Has got it.
Has been recalled.
Recalled. And it's really
Continue.
it has been recalled and not the order of transfer. So transfer order continues.
Transfer order continues, but recall order is.
Obviously, recall order, relief order is there. Now, the transfer order continues because of this relief order was passed during pendency of the writ petition. That is why it was required to be recalled. Now, the transfer order is to be effected. Thus, transfer is not effected. This man is allowed to continue as a principal, and we are subjected to continuous series of harassment.
My lords, opposite, kindly see the prayer, my lords. The prayer against opposite party number 6.
Relieve him and
My lord.
hold disciplinary inquiry, etc.
My lords, unless notice, let notice go.
Notice has to.
Notice has to go, my lords, I don't have, but only a small prayer, my lords, pendency of this, because transfer order is there, it should be given effect to that.
No, that's all right. But unless why, what happened, etc. You have seen you're right that you are highlighted. That is covered by judgment of the apex court also. Shivdev Singh. Versus, so in 63 or 64 Supreme Court, I don't really take off that judgment. Where they said you were not made parties to that. No. That's what. Therefore, you are entitled to maintain this petition, which is that Shivdev Singh versus. Anybody remember 63 or 64 Supreme?
Generally remembering the name of Shivdev Singh.
64, 63. Where is that? Not Shivdev. That Shivdevo. SHIVADEO. Not Shivadevo. DEO. 63 or 64 Supreme?
Yeah, and 63 Supreme.
63 Supreme Court. You are right.
1909. 19 page 19.
Yes, 19. So you are right. Just look into that. Notice has to go.
Notice has to go. Well, I don't have another. Only small prayer matters in this regard.
We'll post it immediately after vacation.
I don't have an objection to that. Only thing is that small prayer. Thing is that they have not placed the thereafter they are recalled and the petition was not placed. The disposal was not placed. So they
is pending.
Disposed of, not placed. My humble pendency of this writ petition. The matters of fixed a shorter date. Shall not be barred to take a decision upon an except for. That is what my humble request.
Oh.
Call this matter on 15/10/2025 and which OP should implement that?
OP number, the managing
president. The pendency of the petition will not come in the way of.
Well, opposite part number 5.
Transfer order being given effect to as against OP number 6 pursuant to transfer order dated.
Transfer order dated 23rd October 2024 in Annex 4.
23/10/2024 at Annex 4 being given effect to petition OP number 6. Right now, whatever we can just do. Being given effect to.
I will take notice so far opposite part number 6. I will take notice through
AGA for 125.
6. I will take notice through
emergent notice to 6. Okay. Item 32. Yes.
Here the petitioner was initially appointed as assistant teacher way back on 1/7/1989, my lord. And after continuing for last more than 10 years, on 10/7/1999 was terminated by the managing committee.
when the school was on unrated one. And as per the government supply, he prepared an appeal before the appellate authority, that is Director of Secondary Education. That appeal came to be dismissed on 12/8/2003, and thereafter he filed a petition that was also dismissed. Thereafter, a review application was filed with the petitioner. That review has been allowed on contest, Annex 2, my lord. Kindly see the review order by Annex 2, page 22. My lord Justice, my lord, the division bench judgment. My lord Justice, Chief Justice, my lord Gopal Gowda, and my lord Justice B.N. Mahapatra, page 28, the operative portion. Para 8.
Well, name should not be
Well,
spelled.
in para 8, in view of the above, we direct the opposite parties to reinstate the petitioner, in the post of assistant teacher in so school with immediate effect, but without any financial benefit, and provide necessary facility and opportunity to the petitioner to enable him to undergo BEd qualification. The private opposite parties need not be displaced if any of them is appointed in the place or post of the petitioner on account of this order. The petitioner can be made to work against any other vacant post or supernumerary post until the vacancies occur.
Now what happened?
Now, my lord, this order was not carried out until 2014, my lord. Ultimately, 2014, Annex 3, 3/12/2014, after I filed content, they complied and allow me join on to
After how many contempts?
after my one contempt. One contempt. That time that was only one contempt.
At that time, only one contempt.
One contempt.
That multiple contempts came when?
Later.
Yes. Now what happened?
Now my issue, my lord, the after I joined Annex 3, the institution already notified as an aided institution since my lord 2004, my lord. That is Annex 4. You also kindly mark page 30.
Yeah.
Annex 4, the institution was declared aided. With effect from 1/1/2004. Therefore, page 30 to all the other employees having extended the benefit of granting it. But
take notice.
This can be disposed of, because the issue has already been decided by this on court, relying on judgment. Annex 9, also kindly say Annex 9. This very issue has already been decided by this on court, page 47.
We can direct consideration of your representation in terms of 26/4/2023.
Yes. That Annex 9 judgment, madam, which is already upheld by the appellate court.
That's what. Right. Petitioner's prayer is as answered. Next paragraph. Learned counsel for the petitioner submits that his client has already made a representation dated 14/9/2025, quoting all relevant rulings.
The representation dated 20th May, my lord.
14/9/24 is
68, page 68.
68. Last depend 20th May.
Dated 20 May 2025. Wherein at Annexure
10 series.
Annexure 10, wherein the prayer, the last paragraph reads as follows. Next paragraph. Counsel for the petitioner submits that if a direction is issued to consider the subject representation in a time-bound way, keeping in view the facts stated in therein, his client would be satisfied. First one. Next paragraph. Learned EGA appearing for the OPs in all fairness submits that he would instruct OP number
1, madam.
OP number 1 to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law, if all contentions are kept up. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, petition is disposed of 8 weeks. Solicit no cost.
Taking in account Annex 9, the judgment of the Ivory Lad.
You speak that keeping in view the decision of coordinate bench. Coordinate bench
decision already upheld by the appellate court.
Decision in WPC number 14995 of 2016, disposed of on 26 April 2023. Okay. Yeah, we structure that.
Item 33.
Here the petitioner's annual increment has not been paid since 1/6/2025.
1/6/25.
Because there is a departmental proceeding initiated on 13/5/2025. But there is no
13.5. Pendency is not a ground.
not in.
Conclusion is a ground.
Yes. Lordship is correct.
Yes, brother, what is Apex Court said? Pendency is not a ground
Yes,
for
yes.
withholding increment.
Well, I will take instruction because there are article of charges, which is also appended to this writ application.
Correct.
There is.
And this is recently in the month of June. So far this representation is concerned also in the month of July. They are saying that from 1/6/2025 onwards. I will take instruction.
Okay. No, what he says is to consider this
Increment.
representation because it is not yet concluded. If the punishment is imposed, yes, you are entitled. But in anticipation of that one, you can't do that. That's what the Apex Court has also said. You consider that representation.
It is at page 55.
Huh? Page 15. Correct. Perfect. The short grievance of the petitioner is reflected in his representation dated 19/7/2025 at Annexer. What is this Annexer?
Annexer 6 series.
This is
At
six
page,
series.
you can say at
Page 55.
15. First. The same is reproduced below. Okay. Next paragraph. Page 55. Reproduce that. Next paragraph. Learned counsel for the petitioner submits that withholding of increments that have accrued due cannot be done on the ground that disciplinary proceedings are pending. First off, that is how most of the popular service have a point, like Justice Ramajais in his services under the state, and Mr. Samaraditya Pal in his law relating to public service. First, next paragraph. Learned AGA Mr. Mohanty, on request appearing for the OPs, although initially resisted the petition, now very fairly agrees that he would instruct OP number.
OP number 2 and 3.
OP numbers 2. It cannot be 2. Any one, no?
Well, this is 3.
OP number 3. To look into the grievance of the petitioner in a time-bound way and in accordance with law, if all contentions are kept open. First, with this proposal, counsel for the petitioner is also agreeable. Next paragraph. In the above circumstances, petition is disposed of. 8 weeks. Open to solicit. Now, no course. Okay.
Stipulation time may be framed.
Yeah, 8 weeks. 8 weeks.
And the result thereof should be communicated to the petitioner.
Yes, that also included. It's a standard format.
Item 34.
Yes. Yes, 34.
Very clear.
Yes, sir.
Well, particularly the small scale industry is applied for a tax, and that has been
allotment of land. You take notice, sir. It cannot be done. Anything cannot be done.
That has been rejected.
It's rejected.
Since 99, it's continuing enough.
Issue emergent notice. Mr. Mohanty appears.
No, here they have not served because they have possibly made IDC as a party. They are the panel of
Issue
lawyers.
emergent notice. It is in addition to taking usual steps. Petition may serve a copy of the petition on any of the panel advocates appearing for the OPs.
My lord, I have filed a IA for no courtesy action because they have already rejected. They will take step for eviction.
You just take that.
Status quo may be.
If any allotment is made, the same shall be list pendants. Shall be subject to list pendants. Okay.
Okay.
Item 35. My lord. Well, in this case, the petitioner is challenging the action of opponent party number 1, 2, 3 in not taking any steps for approval of appointment of the petitioner as additional section teacher at Laramba High School, District Bargarmal.
When he was appointed?
Well, the petitioner was appointed on 27/8/1994, my lord.
94?
Yes, 1994. From that day, he is essentially continuing his job without any break.
If they consider your representation, all right.
Yes, ma'am.
But
petitioner has scripted the prayer as under. First off, learned counsel for the petitioner submits that in connection with his client's grievance, a representation dated 20 August 2023 at annexure A13 has been submitted to the Commissioner cum Secretary to Government, and that the same remains unconsidered till date. First, learned counsel also cites Article 350 of the Constitution of India, which mandates consideration of grievances of the citizens in a time-bound way by the concerned officials. First one. Next paragraph. Learned AGA Mr. Mohanty, on request appearing for the OPs, very fairly agrees to instruct OP number 1 to look into the grievance of the petitioner as has been aired in the subject representation and to do it in a time-bound manner. First one. With this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, petition is disposed of 8 weeks. Open to solicit any information document from the petitioners. All right. No question.
Deeply obliged, madam.
No.
Item 36.
My lord, petitioner is a proprietor of Mahaviri Printers, A8 of commercial estate Raurkela. Petitioner challenges the inaction of the opposite parties in not converting the lease shop cum residence A/80 commercial plot to the freehold. My lord, a petitioner has a taking possession since 40 years, my lord. He has
emergent notice.
No, in the instant case, I have filed a representation annexure 8 before the opposite party not to.
Who is OP2?
OP2 is the
notice has to go to them, na?
IDCO.
My lord, IDCO Managing Director, Odisha Industrial Infrastructure Development.
No notice be issued.
Not required, my lord. Only I respectfully submit that
you bring their advocate. I will dispose of that matter.
Representation may be disposed of directing to the
without hearing him.
No, my lord,
at least his presence should be before me. Na? You bring that advocate. We'll make that order to consider. Advocate. Suppose if that order is put in, they should issue emergent notice. You, OP, Mr. Gama.
I am for one. Who is for?
Yes, for 1. Emergent notice to 2. Post immediately after service. Okay.
Well, the pendency of the case is not a bar to consider a representation.
The pendency of petition would not be a bar for consideration of petitioner grievance in accordance with law. Okay.
Under annexure 8.
In terms of annexure 8. Yes.
Item 37.
By page lordship. Whereas the petitioner before a lordship was a Sikha Karmi, appointed as a Sikha Karmi, by virtue of the
date of regulation has to be. They have done regulation with effect from which date?
It was on 89. Only date has been changed from 31st January.
31/1/89.
27th December.
Yes, retrospectively they are regularizing me, but my predicament is that because of this, I may be my pension and other calculation will be prepared. That's why my date of appointment is 27/12/89. By virtue of the annexure 4 and by virtue of the annexure 5 of the DIF school, they have regularized me from 1st January.
You have given representation on 10 January 25. Let them take a call on that. All right. But petitioner has scripted his prayer as I went. First off, counsel for the petitioner draws attention of the court to his client's representation dated 10/1/2025.
Two representation
6. And
OP number 4. In fact, they have made
also
2 representations.
11/8/2025 at annexure.
This is at annexure 6 series.
Annexure 6 series.
6 series. 2 representations.
Counsel for the petitioner submits that despite multiple representations, grievance of his client has not been granted redressal, and this is violative of Article 350 of the Constitution of India. First. Next paragraph. Learned AGM Mr. Mohanty appearing for OPs very fairly submits that he would instruct OP number
3 and 4.
OP number 4 to look into the grievance of the petitioner as has been aired in the subject representations in a time-bound way and in accordance with laws, if all contentions are kept open. First, with this proposal, counsel for the petitioner court and courters. First, in the above circumstances, petition is allowed 8 weeks, open to solicit, no course. Yes.
Item 38.
May please. In this case, petition seeking activities regularization matter. You will also dispose of identical matters matter. I have corrected copy of it.
You have corrected the date. You have given copy to your friend also.
Yes.
You should know.
Annexure 8 to be considered.
Yes, ma'am. 45 also same.
Next also.
45.
45 date?
Date.
Yes,
date.
take that 45 also.
Good language.
Give that copy to pen of 45.
Good language.
Yes.
Item 39.
May please your lordship.
Yes.
The petitioner is a lecturer.
Lecturer.
Yes. He has come before lordship. Mr. kindly see
Release the salary.
Short-term recovery. Annexure 3. I have no grievance against OP number 1 and 2. Is the grievance against the
Your
government?
salary is recovered now.
No,
Not
they have
released.
noticed me to recover.
They have issued notice to you.
Yes. Annexure 3.
8925.
Yes. Without giving an opportunity whatsoever so cause.
Why they want to recover?
No, they said that I have received excess salary.
Excess salary.
Yes.
During the period between
2009 to 2025.
how many years of service you have got?
Since 1994.
No. How many more years of service you have got?
No, only 3 months there.
Only 3 months. Now, if, suppose if I stay and you take away the money, how to recover it?
No, Lordship, it is my legal entitlement because your Lordship kindly see, I joined the service way back in 1994. The college was notified in the year 2009. They only paid the salary 2025. They were paying, the OP number 3 was paying only rupees 500. Thereafter in 2009, only 700. So they were not paying anything. I was just working in the college with an expectation that after the college would be notified to be an aided college, I would get the benefit.
It was notified as aided when?
Yes, only to April 25, Lords.
April 25?
Yes, my Lord. Annexure 1.
No, my question remains as it is now. You are not answering it.
Yes,
Suppose if we halt the recovery and you retire.
that time, Lord, there is a provision that can be recovered OPDR under OPDR Act also.
How? That answer entire.
No, they say, they Lords, in the order of approval itself, it has been mentioned. Supposing there would be an excess, that can be recovered.
That will not work.
So, my humble, respectful submission to Lord.
Take no emergent notice. We will call this matter in the anyway in 3 months you have got nas. Before that I will dispose of.
They have also Lords not paying my monthly salary last month.
Last 8 months they have not given.
No.
Now we have come.
Yes.
So we will call this matter immediately after occasion. Issue emergent notice. Mr. Mohanty on request accepts notice for the OPs, all OPs.
My lord, the OP 3, the order passed, which is the impugned order. This is by OP number 3.
3.
Private OP.
You do not appear.
No, I have no grievance. They have paid this, sir.
I want to. So because I have to send
1 and 2, that I can. But 3 notice is to be issued.
Emergent notice to 3. Post this matter after vacation.
Well, Lord, recovery they will.
No.
Immediately.
No recovery. I will not. Otherwise, because you have got only 3 months. Suppose if for 4 years I would have stayed.
Lordship, kindly see the judgment supreme.
Instead of, I know all those judgments.
Lordship, there are lordships in
Massey, 2015 Supreme Court.
Yes.
Thereafter, 2 more judgments have come which are more favorable to you.
Yes, Lord. Still I am. Jagdish Prasad Singh versus State of Bihar.
That part. Wait. Let's notice. No. Chalo. Yes. Pasol.
Item 13.
हाँ.
30 wala subsequently it has disposed of, no? 30.
13, my lord.
You appear.
Yes, my lord. Yeah. My lord, on behalf of Mr. Ashutosh Mahanti, my lord, I may permit to place the matter, my lord. My lord, I am challenging Annexure 4, whereby I have applied for the position of
Guest faculty.
Yes. So my contention is here that they have not recruited in the select list two number of candidates in accordance to the UGC norms. As per the UGC norms, my lordship, they required for recruitment of assistant professor either NET or PhD.
Any one of them.
Any one of them can minimum qualification. But my lordship, kindly come to page number 28. At serial 6.
6. Dhani Soren.
Yes. One candidate number 1 is a PhD degree holder, but the subsequent Sanjana Das and Dipti Sri Rai Chaudhary, they are not even
no NET, no PhD.
No net PhD.
How you will say that? They don't have the said qualification. On what basis you form that opinion?
My lordship, on query, my lordship, they have replied that.
Where is that?
Reply that not my. I have annexure 4, my lordship. Kindly come to annexure 4. That I have given a mail on this regard to the principal. That the interview for engagement of guest faculties was held on 19/8/2025 as per the UGC and ICT regulation. The minimum eligibility for teaching physics courses at both BTech and MSc level is NET PhD in physics. However, the institute ignored the requirement selected.
Take notice. Take notice. Emergent notice. OP, Mr. Mohan,
2 and 3, they are all independent.
They are independent, no? 2, 3, 4 also.
4, 5 also.
5 also.
Except 1.
1, 3.
Because UGC is there, panel of forms.
Emergent notice to the rest.
My lord, sir, you file one IA for stay of operation.
Why stay of operation? Nothing is going to happen.
A date may be
Post immediately after this. Teachers' appointments should never be stayed.
My lord,
because they will teach at least. So there will be some teaching, etc. Subsequently, let us see.
Item 40.
This is a case of transfer. Your lordship may kindly turn to annexure 3 at page 20. My lord may kindly come to relevant page 23. Serial number 40. 40.
Shishir
Kumar Patra, Senior SCS Headmaster. He has been transferred from Huamara Government High School, GB Nagar, in the district of Mayurhanj, to Government High School, Boriguma, in the district of Koraput. That is 800 kilometers away. Another ground, your lordship may kindly turn to page 24. My lord may kindly see, this transfer has been made in own request. No TA/DS.
He has not made request at all.
Not at all. And my second ground is, my lord, this has been done at the instance of the MLA basing upon the government order dated 13/5/2025, wherein, my lord, Annexure 4, wherein 15 names were recommended, and I am one of them. I have categorically avoided in paragraph 7, and I have also implemented the MLA as a party.
Issue emergent notice. Mr. Mohanty accepts notice for 1, 2, 3. Emergent notice to 4. Stay of impugned application is moved seeking interim protection against the transfer in question. First off, that the counsel appearing for the petitioner urges that the place to which his client is now transferred is about 800 kilometers away. It's semicolon. Secondly, his client had never made any request for transfer, and despite that, the transfer order says it was made on request, and therefore he is not entitled to TADA. Semicolon. The transfer has been effected on the influence of OP number 4.
OP number 4.
If OP number 4, they are relying upon the circular in under Annexure 4. But they have added him as a party.
No, that is required.
That is required.
I'll tell you why. Well, at that time, I'll tell you. OP
And
number.
my lords, that Karnataka decision also there in the policy. Series of matters are there.
There. We will put all those matters and but that was not a matter relating to teachers. It was some other employees.
Recommendation of
Recommendations of this. First off, there is prima facie force in this submission, and therefore interim order needs to be granted, as has been granted in other similar matters. Yes. First off, next paragraph. In the above circumstances, the impugned order of the application is there was impugned order dated
37/2025.
25 is at Annexure 3 is stayed so far as petitioner is concerned.
My lord, in respect of the petitioner, because
In respect of the petition.
Deference, petitioner is concerned.
And he may be allowed to continue.
The petitioner shall be permitted to continue in the service in Hon'Ble school.
No, in Kumara Government High School, GB Nagar, Mayurbhanj.
Science. As before.
Yes.
Till next day of you. Okay. Yes. Item 41. Yes. All this matter along with WP number. Mr. Swin, give that.
Item 41, before my learned senior begins, I'm entering appearance on behalf of opposite party number 6 and 7.
OP 6 and 7.
Yes. So also I'm filing a senior memo for my learned senior Mr. Hunia. Copy of the writ petition will be served upon me.
Well, sir, certainly he is appearing, I cannot deny that. But the thing is, it is slightly different. Here, the case is...
This is after notice.
No, this is the first admission.
First time.
Yes.
Well, I have not issued notice at all. I may not issue. How do you suppose?
I have telephonic instruction to appear in the matter.
Even without notice of the court.
In order to avoid any interim order to be passed.
But then you enter caveat.
Pardon, my lord?
You have to enter caveat for that.
Yesterday only it came to the knowledge of the said party.
You could have brought caveat now.
No, because there
For preparing caveat petition, how much time is required? 3 minutes.
My lord, there is no impugned order so as to prepare a caveat.
Then why do you worry? Let us see.
Well, this is a case regarding obstruction caused to the transportation of gypsum. Because yes,
Gypsum is a fertilizer.
Yes, but for the purpose of preparation of road, this is the
gypsum is for laying the road.
Yes, but that is to be the offshoot that the counter blast of those gypsum is to be used in the road preparation.
Now, who is coming in the way?
because the truck associations of local truck associations, they are not allowing us to move.
But correct, what the read court should do?
So read court, previously, there has been a direction regarding the same issue,
Saying
two writ applications are there. I have given annexure 8 and 9.
now
Third, there should not be any law and order situation.
Huh?
There should not be any law and order situation. But I have got 250,000 metric ton of gypsum supply. I will be purchase orders. I have given the purchase orders. The entire endeavor that I should include their trucks, the allegation, they wanted the trucks of those associations are to be utilized because they are charging higher exorbitant trade.
Yes.
That is why, If you also look at the last, in the same area, annexure 8, page 35. Same situation arising in 2022. Number of cases were there. And direction was there to the police and district administration to see that there should not be any law and order situation. There should not be any physical obstruction. And they have also given assurance they are going on. Now, this since I have received a purchase order, that's why they are creating this. And I have given a representation to district administration.
Yes, when you should carry transport those things.
I have been carrying since 4/9 because I have given the purchase order.
One second. One question. One answer. You should not confuse me more. Your purchase order is dated?
Purchase order is
8/7/2020.
8/7/2025 and 12/9/2025. And another is 1/8/2025, annexure 3.
3 purchase orders.
Yes, sir.
Who has placed these purchase orders?
IFCO, If you also look at
IFCO, is it a private company or a public sector undertaking?
Orissa Cement Plant and IFCO.
Whether they are a public sector undertaking? Private.
The manufacturing. Can you see annexure 5?
You are only a carrier.
Yes. Can you see annexure 5, page 26 for a minute?
Lifting of gypsum from IFCO premises. You want to lift the gypsum from the premises of that factory?
Yes, sir. And I have
take it to the spot destination.
Throughout the state.
By trucks,
Yes.
Because you have won the tender for that.
Yes, sir.
Where is that tender?
Tender, that is purchase orders, Annexure 3, can you see page 22?
This
that was 50,000
cement plant. Is it a public limited company?
Private company.
Private company.
Private company.
Yes. And this fertilizer,
they also participated in the tender.
I don't know because I have received purchase orders, and their associations. I am a carrier, sir. Can you say I have given the mail issued by IFCO that not a single ton had been lifted so far?
Yes, brother, what do you say?
It's all the way the dispute relates to lifting of the gypsums, and they are all private company, those who have got the benefit and also the carriers.
Yes.
From one destination to another destination. This is nothing to do with so far the read code is concerned. This can be, they are saying that it is being obstructed by the opposite party number 6, 7 other associations.
No. 2 things. Right to do business.
Yes.
Right to do truck business, transport business is a fundamental right. Number 1. Number 2, right to move from one place to another is also a fundamental right. How can you say it's a private dispute? If somebody comes in the way, it's your duty to ensure that they do not come. It is not that private.
They are anticipating so. They are anticipating because
see, those they are anticipating, it is like anticipating that gangrene may develop. One need not suffer gangrene and go to operation theatre.
At the earliest.
I can take all precautions because earlier round of litigations.
The FIR has been lodged before the police station.
Then step into that.
Hey, recently, my lord. This
Recent-
is
on
9/9. On 15/9.
What should be, what has been done?
No, that I have to take into because
That you
15/9.
have to do. Otherwise, they will register another counter register, counter FIR, and the police officers will be very happy.
15/9 FIR was lodged.
15/9.
15/9.
Yes.
As it
What
happened.
has been done? Who is arrested? What action is taken? Registering FIR.
Your Lordship is correct. Your Lordship said the counter FIR. My FIR is 9/9.
What action is taken against him or against them? Whether your police officer wants to do something or I should do something.
And let me take instruction. So far, this information is concerned to the police, jurisdictional policeman.
What they have done, when FIR, what the Apex Court said in 1955, once FIR is lost, they have said 5 steps to be taken by the police. What has been done? Even that is repeated in Lalita Kumari, state of UP or MP, 2013 ACC, UP. What they have done? Otherwise, how, if the business does not happen in the state, how state will prosper? That becomes like another country like Nigeria.
Not if I may.
Who are you?
I am the opposite party number 6.
Who has issued notice to you?
My lord, I'll just
Don't argue. We are not put to
misleading statement is being given.
you.
I'm the opposite party.
Where have I issued notice to you? Kindly take your seat. You have not filed a caveat also. Where is your right of audience?
My lord,
Please, kindly be seated. Kindly be seated.
My lord,
That's the law.
I just may be permitted to at least give.
Why you should be?
Two aspects.
Other people from Cuttack market will come and I say, no, we also be permitted.
I'm the party in this.
I have not issued notice. I am asking the state. I may not issue notice to you at all.
Not because
You have not entered caveat.
Because, my lord, there are 2 misleading statements being given.
Who are you?
I just want to clarify on that.
Who are you?
Through
No.
they are taking.
No, kindly sit down. We will not hear you. First, I have to ask them. I may not issue notice to you. What action the police has taken?
My lord, let me take instruction because it is from Jagatsinghpur. Let me take.
Issue notice only to OP number
OP number
1 to
1 to 3, my lord. 1 to 5, me.
1 to 5.
Exactly.
Yes.
Because they are all status.
1 to 5.
1 may not be good. 2 to 5. They are the
2 to 5.
Exactly.
Why 1 also? State is also responsible.
1 to 5.
1 to 5. No notice to be issued to rest of the OPs now. Okay.
Natural right will be violated.
What is your right to be violated? You file impleading application. I don't issue notice now. It is prerogative of the court, brother. How can you say that you should be issued notice? It is like saying I should be invited to the marriage. Nobody can say that.
I humbly bow down, my lord. But there are certain facts which needs to be brought up before this honorable court. At least I may be permitted to appear in this matter and file a counter, man. Otherwise,
Why you worry? I have not issued notice. I may not order any, make any order against you. You go on doing whatever you want to, and police will look after the rest of the things.
ultimately, my lord, the business of opposite party number 6 and 7 is also in concern, my lord. Otherwise, my learned senior would not have made me a party.
But he may make all 145 crore people in the country as parties. But it is for the court to decide whether to whom to issue notice, whom not to issue notice. That is not the point. Point is, if these things are happening, how the state will prosper? Who will make the roads? Do you know the roads on which we are traveling in our car? Earlier in our state, we used to correct judgments because we spend a lot of time in car than in house in Bangalore. We used to correct all our judgment. Now, it is impossible to sit unless we hold both the sides with our hands. We may go to the other seat. That is the position. Number 1. Number two, whenever business prospers, the state prospers.
But that is my point. The business is happening. Is lifting the gypsum through us only.
Yeah.
So that's a misleading statement which is being given before this Hon'Ble Court. That is my first point, my lord. And the second, sum of substance is, my lord has said that the petitioner is a carrier. He has not given the license. He has not been issued the license under the carrier by road.
page 34.
All these things have to be brought to this notice, brought to the notice of this Hon'Ble Court. my lord.
Let us see them. Let us. We don't issue now notice because you can't invite notice.
I am not inviting, my lord, but I have been made party, my lord.
No,
At least I
I'm
have
saying-
been permitted to appear in this court.
Brother, even when court does not want to, still you want to. And to make adverse order against you, I hear you, I can understand. I am not passing any adverse, I am not issuing notice also to you. You should be very happy, you should tell, you take a double fee from your client. I have ensured no order is passed against you today. FIR is lost. What has the police done in the light of Lalita Kumari?
Yes.
Tomorrow you should say that. What action you have taken? There are FIRs and counter FIRs. What action you have taken? Maybe against him also.
Yeah.
We do not know. What action is taken?
Let it be day after.
Day after?
Yes.
Call this matter a day after.
Item 42.
May I please? Matter relating to grant of arrear salary. Now, out of 3 matters, last 2 years you already disposed of 2 of the matter. I have given the corrected copy.
Have you corrected all the
Yes,
things?
yes.
Yes.
Both the matters same. I have given 2 orders, ma'am. 2 corrected copies.
2 different corrections. Yes.
Item 43.
May I please?
Yes.
Matter relating to allegation of multiple allotment. Under Annex 22, Lordship has given the judgment in the light of Susama Mishra versus State of Odisha.
It is covered by that judgment.
Yes, ma'am.
Let notice go.
Yes, ma'am.
Issue emergent notice. AGA for OP number 1. Emergent notice to the rest. Application is moved in IA number so supported by affidavit. Seeking interim protection. First up, learned counsel for the petitioner's presence into service. A decision of this court in Mishra versus so and so. Give them. In support of his contention application. First up. A prima facie case is made out for affording interim protection. First up, in the above circumstances, application having been favored, impugned order is stayed till the next date of hearing. Okay.
44.
May I please, Lord?
Yeah.
Here, my lord, the petitioner was appointed as a teacher in art, my lord, in DAV school in the year 2012. And
Petitioner's daughter should be permitted to prosecute study.
my lord, what
Daughter
happened?
is a minor.
Minor, like she is studying in class 4, my lord. And what happened, my lord? The petitioner was terminated from his service after 12 years, my lord. My lord, on the ground that he, my lord, sought for from the management to regularize his service.
Huh?
For regularization of his service, he approached the authority after 12 years of service. And instead of regularization, he was terminated from the service. Your tenure is completed on 28/3/2025. Because from time to time, his service was renewed from time to time. And his services were terminated, and the termination was challenged before the Hon'Ble Court, and the Hon'Ble Court granted leave to the petitioner to approach the director. I have filed the appeal before the director. My lord, fact remains, my lord, now the daughter of the petitioner, my lord, is going to appear in the half yearly examination, and after filing this petition, they have allowed. But I am retaining the quarter. Where, my lord, I am residing with my family members, my lord, when I was, my lord, working
Now, my responsible prayer, additional prayer, my lord, let me allow to my lord, retain the quarter at least till the academic session is over.
Academic session will be over when?
Lord, March, my lord, 2026. And
But you are no longer in employment.
that is true, my lord. Because your lordship can see, I have approved the, my lord, the director by filing appeal. Appeal is pending. No, appeal has not.
Interim order granted.
No, my lord.
Then how can you retain the quarters?
That, my lord, I have, my lord, I approved the director to grant any interim order because this is the, on 4/9/2025, they issued the, my lord, the order to vacate the quarter. The director neither, my lord, had the matter, my lord, on appeal or the interim application.
No, what's your right to continue in the quarters? Suppose after my retirement, if I retain the quarters, what will happen?
What happened?
What is your right to continue in the quarter once employment is terminated?
No, only ground that we are retaining the quarters when the quarter was allotted in favor of the prisoner on the monthly rate, which was deducted from my salary.
Now your salary.
Yes, I am ready to pay the usual rent.
It is not for that purpose. Quarters are meant for those who are in service.
That is only internet period that my appeal till the academic session was over or the appeal is disposed of.
I'll give you 1 month time. 1 month time I'll give you. Before that, you make alternate arrangement. Apex Court, you have seen one judgment where Apex Court used army people to remove certain persons. There is a reported judgment. You are not supposed to retain. We are not supposed to retain the quarters after employment comes to an end. Maybe by termination, dismissal, removal, retirement, resignation.
That is the one I have challenged that.
But that is wrong.
Yes. And that, my lord, my second prayer is that the appeal pending for the director.
That will direct them to dispose of the appeal.
Yes, that is. No, at least, my lord, I think either within 2 months or 3 months, the appeal may be disposed of. Till then, my lord, I may be allowed to retain the quarter. That is,
No. The appeal will be taken up after you have delivered back the possession of the property. We can't link it that way. We can't link it that way. You are terminated. Which year you were terminated?
My lord, 28/3/2025.
28/3/25.
My lord.
Now already how long you have been here? Nearly 6 months.
Yes.
You have been in the quarters. These quarters are meant for employees, not for those who cease it to be in employment. Therefore, that cannot be granted.
May I submit one thing, my lord?
Yes.
Lord, your lordship can direct the director to dispose of my appeal. And in addition, my lord, my interim application filed before the director may be considered.
That will happen provided you deliver back the possession of the property. Because there are many people in queue who want to occupy.
The lordship directing that within 1 month I shall make the arrangement. And within that period I shall the application filed before the director may be, my lord, considered.
No.
Disposed.
Within not that. After 1 month they will give you. After you deliver back the possession, they will take up the matter. In the event you do not vacate, I will direct the police to remove all of you from the concerned premises. That is the correct position of law. It's a public property. It cannot be retained by a dismissed employee, removed employee, retired employee, resigned employee. Take note. Petitioner has made a slew of prayers that read as under. Next one. Learned counsel for the petitioner submits that he has preferred appeal against the termination order dated 28/3/25.
Lord, that is under Annex 1, my lord.
The termination order is dated
28/3/2025.
28/3/2025. And in appeal. And he has moved an application for interim relief at the hands of the appellate authority, which remain pending consideration. and therefore, till the appeal is decided, the council submits, his client should not be removed from should be allowed to continue in the official quarters. First, learned ASC on request appearing for the OPs. All OPs.
No, 1 and 2, my lord.
1 and 2.
One of the management school, my lord, appealed to the CBSE.
Opposes the petition, contending that after cessation of employment, no ex-employee is entitled to continue in the official quarters. Semicolon. These quarters are meant for the people in public employment and seekers are in the queue. First time. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court is broadly in agreement with the submission of learned counsel appearing for the state. First time. However, so far as consideration of appeal and application filed therein, there should be consideration thereof at the hands of the appellate authority is strict. First off, some reasonable time needs to be granted to the petitioner to vacate the premises, since already he has been there a little less than 6 months. 6 months. First off. Next paragraph. In the above circumstances, petitioner is directed to deliver back peaceable possession of the subject official quarters to the concerned, yielding it for others' occupation within 1 month from this day, failing which the jurisdictional police shall on the production of this order remove the petitioner by using reasonable petitioner and remove the occupants of the quarters, including the petitioner and the material, by using reasonable force therefore. Next point. The appellate authority, who is OP number?
OP number 3, my lord.
OP number
3, direct.
3 is mandamus to hear and dispose of the appeal, as also the application within 3 months from the date the petitioner vacates the official quarters, as indicated above. First, if the petitioner does not vacate and vacate as indicated above, both the appeal and the application shall be dismissed in limine. Okay.
That your lord's minute. I shall, because my, I will
6 months you are already there.
No. That is because my daughter is studying and
2 months, make it 2 months. Otherwise, after 2 months, if you do not, 2 months, that is to make the date also this day. Or you can say 2 months should be high now, on or before 30th of November. Instead of 2 months, it's structure that judgment tactic. Registry to send a copy of the judgment to OP numbers. Who are the other OP numbers?
2
and 4. And also 2 the superintendent of police, which district it is?
ढेंकानाल, my lord.
So and so for necessary action. Okay. By speed post. Okay.
Item 46.
May I please, my lord?
Yes, sir.
My lord, the petitioner was appointed as principal of the college by the order under Annex 2, your lordship. My lord, while he was continuing as principal, he was demoted to the rank of reader and somebody else was appointed as principal in charge.
The same matter which...
and continuation. I will show you to your lordship that how this the opposite parties have been playing with this code.
Which is that other matter connected with this now?
No, not connected.
This is the matter.
This is the matter.
That other party retired.
No, connected matter was yesterday. This is a fresh matter.
This is another matter.
Another matter.
Why?
Because they have done so. I'll just place 2 minutes, I will take.
No, we'll call this matter along with that matter. That is posted on which day?
On the reopening date.
All right. Issue emergent notice. Who take ASC for? All.
Another in-person.
Huh? 193. You are for 193. Emergent notice 2.
Two is also a government body. He has issued the letter ordered in his personal name. That was
1, 2, 3. Call this matter along with WP number.
I'll give that.
6644 of 2024.
No, that was this petition's earlier matter. I'll give the number.
Give that.
I'll let the IA may kindly be considered.
No, intimate will be granted. So you should not have filed that actually. Yes.
Item 47.
May I please, your lordship? The application has been filed to challenge the arbitrary actions of the opposite party number 2 towards selecting and appointing candidates for junior teacher schematic detrimental to the rules laid under the horizontal reservation.
Who are you?
Malas, I'm the writ petitioner. I'm a candidate who had participated in the selection process.
You were not selected.
Yes, my lords. I was in
horizontal reservation.
Yes, my lords. What happened is women candidates.
Rajesh Kumar Dharia judgment.
Yes, my lords.
My lord, take notice. Issue emergent notice. ASC for
1, 2, and 3, my lord.
1, 2, and 3. Emergent notice. Okay.
Item 48. Grateful, my lords.
May I please, your lord? The petitioner was initially appointed as a lecturer in English in Belagunta Junior Science College. While continuing as he was placed under suspension by the incompetent authority, that is principal.
1/5/22 to 12/4/23.
My lord.
Subsistence allowance not given.
50% they have given subsistence allowance. Suspension order, initially suspension order was issued. Suspension order was quashed, set aside by this Hon'Ble Court in division bench in writ appeal.
Suspension or subsistence allowance?
Suspension order was quashed. As not passed by the competent authority. And subsequently also proceeding was cast by this Hon'Ble Court, coordinate bench of this Hon'Ble Court. I am praying this period should be treated as duty and full pay.
Any representation you have given?
No, they have paid 50%. On repension, they will not consider my lord. Again, I have to file contempt, let notice go, I pray.
At least you should have said because of all these things, you treat it as a duty and give another 50%, remaining 50% as full duty and treat it as full service.
Lordship, as your lordship, my lord.
That will help you.
Mine.
Petitioner has structured his prayer as under. First one. Learned counsel for the petitioner submits that once the suspension order has been set aside by the coordinate bench of this court,
division bench of
this court, come on. The period of suspension has to be treated as regular and full salary for the said period also needs to be remitted to the account of his client.
Proceeding also quashed.
Therefore, I said that having not been done, counsel submits, this court should come to the aid of his client. Next paragraph. Learned the ASC on request of hearing for the OPs
1 and 2, my lord.
1 and 2 submits that Or 1,2.
See, governing body, my lord.
Had an application or a representation been made, comma, the same would have been considered by the concerned authority with the participation of OP number 3 government body also, and therefore its petition should not be entertained. First of all, at this stage, learned counsel for the petitioner submits that the reasonable period be granted to his clients to make the representation and a direction be issued to consider if one is made in accordance with law. First off, this stand is fair. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to petitioner to make appropriate representation within 2 weeks, and if one is made, comma, the OP number 2 by the director 2 is directed to take a call on that and inform result of such call to the petitioner within an outer limit of 8 weeks. Personal, all contentions are kept open. It is open to the OP number to solicit any information, etc. etc. Okay.
What's the time limit? Time limit will also.
8 weeks. For you, 2 weeks. For them, 8 weeks.
One letter. May I pray, my lord? Since proceeding has already been quashed, the suspension was quashed. Subsequently, proceeding was quashed that time.
Yes, it has come. I have said that. Yeah.
Item 49. My lord, petitioners are casual class for employees of Orissa University of Agriculture and Technology. They have filed this case for regularization of their services. Identical matter, your lordship has issued notice and also giving interim protection.
Emergent notice.
That is your lordship that same order.
So Patnaik appears.
My lord. No, SC Ratha for the OUT, Orissa University of
Let you take
Agriculture.
the issue emergent notice.
That is the order your lordship I have given.
Emergent.
Same from the same everything.
But state is not a party.
No, state is party. That is opposite party. 3 and 4. So 5 and 6. 5 and 6.
5 and 6.
My lord.
Issue emergent notice to 124. Sri Mr. ASC appears for 456. First, learned counsel for the petitioner draws attention of the court to the application in I number so and so, supported by affidavit for interim protection. He also tells that in identical matters, that is WPC 24512 of 2025, already interim protection is granted, and the same protection needs to be extended to his clients as well. First of all, there is force in this submission. In the above circumstances, the OP is
It is for 5 and 6. I am for 5 and 6, my lord.
not you.
Yes.
University to continue.
My lord.
Yes.
All matters are same, your lord. 3 matters.
Similar matters.
My lord.
Okay.
Item 50.
Permitted to
You want to withdraw? Why?
It is not take admission, well.
Learned counsel for the petitioner seeks leave of the court to withdraw the petition on the ground that it has become infructuous. First off, he has filed a memo to that effect. First off, ordered accordingly, and WP is disposed.
Item 51.
51, your lordship can have a glance to order dated 15/9/2025. This is a matter relating to that allotment of plot to the defense personnel. I was directed to file the original copy of that photostat copy of the newspaper item. I collected it from the office of Samaj by depositing the requisite cost.
You were asked to, no, This is Oraj. No, where from he got the Xerox?
From Samaj, the publication company, I have enclosed the receipt also.
Provisional money receipt.
Yes. I deposited the cost for that purpose and they issued it.
They have issued this.
Yes. And that is I am bringing on record by filing an appeal petition. And by this, at the same time, your lordship also on 15/9 directed for filing of counter.
Yes, what is being done this is a Navy man.
Yes, madam. That person is also here in the court present. He is 17 years old.
Wait, brother, what has happened now?
My lord, we are filing counter today. We had, in terms of your lordship's direction, my lord, we have given the sum of rupees 5,000, which was received by my family.
Have you paid 5,000 rupees to your client?
Yes.
You have paid it.
No, that is in my pocket.
No, you give it to him first.
Yes, I can give him.
Yes.
But here your lordship see.
But, my lord, the counter, what it speaks, my lord, lordship,
Property देगी कौन तो काउंटर
अपन नहीं ना अभी
हमको दले.
What is the gist of the counter? Just I want to know. I call this matter of regulation, but the way that we should treat our soldiers, our Navy people.
We are giving them utmost respect, my lord. But simultaneously, in the counter, we have admitted that there was a lottery as per paper publication on 23/3/91 in Delhi, Odia Samaj, Delhi newspaper, that is. Accordingly, it was thereafter, my lord, the petitioner has applied, but I was going through in total, my lord. He has applied for the plot, my lord, but that application was incomplete. It didn't carry his signature, what the affidavit.
You should have called him and said, put your signature.
That it was incomplete application he has furnished.
Incomplete means what?
Incomplete means
Signature.
Signature. They have written that in paragraph.
No, why?
Paragraph
did you inform him? Your application is incomplete. Come and complete it.
Affidavit is silent about that.
Which that
My lord,
concerned officer should be made to.
My lord, it is that on verification of the list file, it is seen that no allotment order in respect of plot number 149 measuring 50 feet into 75 feet as per so and so number Mauja Chandrasekharpur was issued at that time in favor of the petitioner Prakash Chandra Das due to incomplete application form, as the applicant has submitted the application form without signature on 13/4/1989, received by the opposite party number 2 on 11/5/1987. Copy of the public notice that it is annexed herewith. Copy of the incomplete application is was also filed herewith.
No, only incomplete his signature. Why did you know? He is a soldier.
My lord, it is humbly submitted. The eligibility criteria contained in the relevant brochure of 1987, the allotment of government land in the new capital Bhubaneswar for residential purpose of 1987, indicated below. The applications which are not accompanied by a sworn affidavit in the prescribed form, incomplete applications and applications received after the prescribed last date should be summarily rejected.
But that is not the ground. That is not the ground. Only ground is it did not contain the signature. Why did you not tell him, you come and sign signature? They are all soldiers.
My lord,
is this the way that soldiers should be treated?
The petitioner had also approached the grievance of the Honorable Chief Minister.
Yes. What Chief Minister did?
15/7, praying for execution of the list deed on so and so. It was prayer of the prayer rejected, and the petitioner was accordingly informed by letter dated 18/9/2024.
18/9/24.
It was
After how many years?
Because he was the grievance of the petitioner, it was rejected. not the list,
Grievance was rejected.
my lord.
I am asking
For execution of list deeds in favor of so and so, after careful examination, department rejected the prayer as a
Mr. G.
my lord.
Is it the way that our soldiers should be treated? Our farmers, our soldiers, our teachers.
Yes.
For them,
Three wings are there.
very important because they guard our frontiers. They protect us. We sit here so quietly because they are ready to lay down their lives at the frontiers of
Highly
our country.
obliged.
What kind of
That's
treatment to the
My lord.
soldier?
That's why these benefits were given to them. But because of the fact that the application was incomplete,
Well, kindly do not say without application did not have signature.
my lord, that is what
You should have told him, Mr. Soldier, you have not put your signature. Maybe you have forgotten. Put your signature. Small card, 25 paise card would have done the job.
but it was of the way back of
So that's all right. At that time, we have our Macaulay mentality and the hangover of the colonial era.
colonial era.
They still continue like drunken people. This is very
This
bad.
is application of 13/4/1989.
89,
No, 87. Page 13, I have given the copy of my application.
87.
Submitted the application form without.
After application, nothing to have like that.
Three were not lawyers at that time.
I was
Kind
there.
of- what
I was
kind of-
there.
Third rate officers. Sorry to say this. Third rate officers. They never go to battlefield. They do not see how people are wounded, how soldiers are mutilated, how blood is spilled on the ground. They do not go to paddy field to see our farmers, how much hard work they put in. They never go to school at all. They all study in Doon school, etc. All babus. What should happen? And suppose if we treat the soldiers that way, what presently working soldiers will think about us? They will say, why wish we at all protect these fellows, ungrateful fellows?
My lord, your lordship. That should be right.
This is very bad. Disturbing it.
Now, my lord,
Now you tell me how things you will keep right, separate the things. Whatever has happened.
my lord.
Tell me what you are going to do.
Now, my lord, it's a valuable line by now, my lord. 87, it was Chandrasekharpur Mauja, Bhubaneswar. It is highly valuable, costly area, my lord.
It has become costly on its own,
And it's
not because of you are doing anything.
no. It's
All lands are going, the real estate prices all over the world are going sky top.
skyrise, my lord.
Yes.
Now, if he desires, I can suggest them to allot him somewhere else
Where will allot it?
within the vicinity of Bhubaneswar.
West. Let him do that.
I'll
Otherwise, litigation goes on like this.
No, that's right. But to my instruction, the plot which was allotted in favor of the petitioner, that is still remain vacant. Other plots are allotted to other relatives. They have constructed their house. They are staying there. Really, except this petitioner.
Something is better
Yes.
than nothing.
That's right.
Tejita panditaha. Same principle. Get something.
instead of recording my concession, your lordship may direct us. So
No, if I direct you, I will direct them to give the same plot. If you say concession, ask your officer.
yes.
I will put it tomorrow. Ask your officer if they want to do it on
Tomorrow, my lord, day after tomorrow.
day after tomorrow. All right.
Day after tomorrow.
If I write the order, I will write the order with the pen dipped in acid.
Yes.
I am telling you.
Yes.
I will not leave officers like that. They should pay at least the whatever amount now price is there. Now, how many lakhs it will be?
Crores, my lord.
Crores. So that they should pay.
Crores.
The concerned officer should pay. Or government should give it and recover it from the officer. This is not the way that soldiers are treated in any country. This is very bad.
Let's may call this matter day after tomorrow. On Friday, my lord.
No, Friday I am not there. Day after tomorrow any.
Not necessary, why you should be there? We have heard you.
Still then,
I am to say,
I feel it proper to appear before lordship, whatever, even though I don't have any choice.
This is important to me, but the justice to your client is even more important.
Madam, that.
Day after?
Day after.
Day after, Friday.
Friday, last working day.
Last working day,
Yes.
it also will be.
Last case, it's a soldier's case, my lord.
Yes.
I am taking priority.
Call this matter at the top of the list. On Friday. But keep your colleague present.
No, still, I can present you through virtual. I can do.
That's sufficient. But something, if I write order, then very bad order I will be writing. Yeah. That will bring very bad name to the government, whichever be the government. It will bring very bad name to the government. So ensure that it does not happen.
I'll try, man. I'm making all my idea.
This affidavit may be one part of the record.
But I'll give that. Okay. Have you served the affidavit?
Yes, I had served.
I have served.
Oh, yeah, this is not necessary because he has admitted in his WS, in counter. All this is admitted, no?
Still then, since that was an order, I am complying that order.
Petitioner has placed, has complied with the order dated 2025 by filing affidavit accompanied by certain documents. Your client has come here. Ask him. Next date he need not come. He appears to be aged, na?
Yes.
Let him not come. Is it? Ask him. Next date he need not come. You tell him in Orissa.
Yes, I have.
All right, okay. Item 52?
I think 52 will be taken up any day after vacation. Next to me, 52. Mr. Mishra, senior advocate, has some difficulty.
After vacation, on the grounds that arguing counsel is not available.
Last order, your lordships passed the order fixing today as a last chance.
Is it?
Yes.
No, last chance was not mentioned, but I apologize because Mr. Senior has some difficulty. Mr. Mishra, senior advocate, has some difficulty. Any day, last chance was not mentioned in the order.
Not mentioned.
No.
Date of hearing. Entry order is there.
Yes.
Yes, stay is there.
In your favor.
No,
In my favor.
in their favor.
In reopening, also take up in the
award was
reopening.
passed in my favor. MSEFC award was passed in my favor. They have challenged that award in this writ application.
And stay.
Stay. My submission is that when there is the alternative remedy under section 34 of the Arbitration Conciliation Act 1996, so this writ is not reasonable. Section 19
Lordship may take up in the reopening week and we'll anyhow argue that day.
On column 2010 2020. 14, 15. How many matters? 15. Call this matter on 15, 10, 2025. Finally, at the request of the net counsel appearing for the petitioner.
Interim order to continue.
Interim order to continue. Only
Who bless me?
Item 53.
The last
one. Yes. That flat apartment matter.
Yes.
Where removal is done or not was the question.
Yes.
Yes.
We have already complied the order, and today we are also filing the compliance affidavit.
Who is there in the building? In the building, who is there? Whoever is there, ask them to call, make video call to me, to you, so that I will see what is there. You will file one affidavit, you will file counter affidavit. How to this? Therefore, I will see with my own eyes.
Yes, I have also the.
Whether your clients are there in the building.
No, their client are not staying there. That is, they have given it to.
Don't allege again and again.
They are using the same
Is photograph
for commercial purpose. That is the whole difficulty. And they are
Is there
employees.
prohibition? Is there prohibition for renting out?
Yes, they have let it out to
Is
others.
there prohibition?
Prohibition means, my lord, they are using it for commercial purpose. My lord, it has been allotted to a particular person for a particular family. Now they are using the running the office there. They are the 20 employees. And the 20 employees, they are using vehicles. They are all entering into the, that is the
You ask him to make a video.
for a minute, 1 minute audience, if your lordship. My lord, I was taking your lordship's suggestion that house and roof is very important. That's why I was not opening with regard to anything apart from this tilt.
it is with
Now, your lordship may see how this man is taking advantage of this, the age, the occupation and simplicity of the persons. This is his application for regularization, what he has done. He categorically said, I have constructed fifth floor of 1477 terrace. And I had been to the spot on Saturday. I found the entire entry to the terrace is blocked. It is opened by around 2 feet to 2 feet. Someone will, I have no what to express. And the entry to the terrace is only through his house. The entire building is on CCTV camera. And the camera had this and everything inside there. You are breaching our privacy. You are not allowing to go to terrace. We are not able to see the water tank and everything.
No, each and every day, my lord, they are making one
This is your application. Nothing.
Initially, all those
One by one, we will go one by one.
Yes,
And if he has done any mistake, you know what I will do.
Initially, my lord.
Now don't waste time.
Yes.
I ask somebody to come, video call.
No, that video call already they are mailed with me.
Give them.
Sabuti khol dele hobo. That entry to the tilt floor. এটা সব আছে খালি খুলতে And your lordship specifically directed that while removing the obstacles and the materials which were stacked, it will be video call. It has also been done.
It's not coming. Why videos are coming?
This I will file by way of and pen drive I can give.
No, we'll check. Only recorded things, only conveniently recorded things will be displayed. That is not, that's useless to me. You ask, will constitute a committee now. Ask your client to pay 10,000 rupees. Where is that building?
It is in Bhubaneswar, India. Around from court itself, around 25 kilometer maximum.
Okay.
From academy, it was 19 kilometer on Saturday. I have been.
Both of you pay each 10,000 rupees.
Yes, your lord.
We'll appoint. Yes, madam. Madam, that side. Yes, both the madam. Both of you come in the front. Now, are you agreeable to become the court commissioners? You will become. Madam, do you have any difficulty? Other madam? You don't want to become the court commissioner? Any other madam? Yes, sir. You want to become a court commissioner? It's an experience. And that will be added to your CV. And I will ensure that you will not be called for examination, cross-examination, anything.
No, madam.
Nothing.
That is not. Only they will go under that something. I think he will.
No. He belongs to our table. We are not allowed. No. No. You know why I am saying so. Yes.
Ladies are always truthful.
Do my mother, my lord, both my sisters.
Ask him.
Another madam is there.
It's scary. Why? I will protect you from. Let both of them go.
C is enough, my lord.
Both of you will go.
And man is enough, more than enough.
No, 2 persons are.
Yes, my lord.
Provide one vehicle
Yes, my lord.
to them. Okay. And I will direct police protection to them.
Yes, it requests. It requests. I also request the technical personnel of BD and BMC also be present with them.
Very
So
so I tell them.
Yes.
Let them submit the report. The lordship is not.
You have not got the copy.
Because the order of the BDA is out of challenge. So now it is not necessary.
To solve the copy before the sunset. You have not solved.
Yes.
BMC. That was the.
BMC
Still
How do you know I have not sought copy?
Then absence.
Well, they may not appear. But that does not mean that I have not sought the copy.
That is what
very unfortunate. We have already received copy on BD. Please.
I have received a copy from
BD and BMC both.
Yes. Yes.
This court wide order dated 10/9/2025 had said as first. Counsel for the petitioner asserts that the compliance is done.
Yes.
And counsel appearing for the OPs denies it. First. Both they want to produce material in support of their contentions. First, that would not much help in adjudging the compliance. First, eminent case is made out for appointment of court commissioners. And accordingly, the following members of the bar are appointed as commissioners, as commissioner. Right now, Srimati so-and-so, Srimati so-and-so. Miss or Srimati, I do not know. Just to say that. Because in our state, nobody writes Srimati, Miss, etc. We will never know the gender of the litigants at all. Nobody writes. Everybody addresses as if they have no respect at all. Yeah. The commission is requested to visit the spot of the building in question and report as to whether the order dated 10/9/2025 is in pith and substance complied with. First, they are entitled to draw the sketch or put the things in writing in addition to videography, everything there, everything. First. Next, commissioners, it hardly needs to be stated, or an extended arm of this court, and therefore the persons concerned shall treat them accordingly. Anything less than that would be contempt of this court. Next paragraph. The jurisdictional police, who is that? Which is that police station? Police station shall provide 4 police constables when the commissioners commission visits the spot for completion the task in question. First, next paragraph. Commissioners shall not be subject to any subpoena, 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 or they shall be subjected to any proceeding as a party, as witness, or otherwise. And they enjoy that immunity. Next paragraph. Both the sides are directed to deposit a sum of rupees 5,000 each in the registry immediately, and the registry shall release that money in equal proportion to both the commissioners. On memo being moved. All right. You want to be in the spot as at the time of no, both you should not be there.
No. Spot they are staying, so not.
No, parties are staying there.
Parties are staying.
My house is not others are there. So the residents are only allowed. Your Lordship may say the residents are only allowed. There should not be, because he is staying with family. So his absence will, because they want to go to terrace through their
No, this does not relate to terrace now.
Only still portion.
Terrace, first we should go ground floor.
I bow down.
First floor, second floor.
No,
we should go gradually. We are not a satellite.
Okay, bow down.
The Lordship has said the report. By whose date the report is to be?
Yes. Commissioners are requested to accomplish the task and submit their report on or before 13th of October.
Vacation, they need some
After
time.
serving a copy thereof on the parties. All right? Who will organize the vehicle for their conveyance facility?
I will.
Not your car. That gives again, some independent car.
You will also provide the conveyance fees. That also required. Let them arrange their own.
In addition to depositing
Rupees 3,000 towards the conveyance fees, man.
5,000 more. Commissioners, they should be in the cars in which judges of the High Court will go.
Yes,
Not
madam.
from 800.
Yes, madam.
Commissioners, both the sides are directed to pay another sum of rupees 5,000 to the commissioners by way of conveyance charges. Okay.
The interim order is there. That
Interim order to cancel.
And
The registry to share a copy of this order. It open to the commissioner to seek all and whatever papers from the respective
yes,
parties.
I will supply, madam.
Parties. That is all.
including
The party shall furnish all case papers for the perusal of the commissioners so that it becomes handy for accomplishing the commission work.
Yes, sir.
Okay.
Item 54. From 54, I am from the opposite party CTL also.
See, you will not call them as cross-examination.
No,
It has nothing. Full protection to
report
them.
will suffice. I hope that report will
Stop.
to decide the case.
Yes.
Saturday the question was posed. Who is there? The question was posed. I had been.
My lord, the petitioner had applied for G category of flood in sector 13.
The 13.
13 in the year 2004.
Four.
And that was refunded by the opposite parties.
Whether this matter I heard sometime.
Yes, my lord. That was interim order also.
Interim order is there now.
Yes.
You'll continue it till after vacation.
Yes, Lord. Now only the interim order was, they said that there is a lottery. So your lordship declared that
Party to go on, but the result shall not be.
results shall not be.
Interim order to continue. Call after vacation. Yes.
Item 55.
55.
Please, Your Lordship. This is the second round litigation where the petitioner has challenged the impugned order under Annexure 6. He was a candidate to an advertisement under Annexure 1, where his candidature has been, he was not given appointment Subsequently, he filed a representation which was not considered. He approached this honorable court. The representation was rejected under Annexure 6. The ground of rejection that though he was his name was in the serial list, in the merit list as serial number 7700.
This is after notice matter or?
Lordship, after notice matter.
For etc. ready, my lord.
Here,
It be convenient to take after vacation.
Yes. For this matter, on 23
Yes.
in the meanwhile, counter if any may be filed, failing which right to file one stands forfeited, and petition averments may be taken with face value. Next.
Item 56.
May I please the lordship?
Petition file number 3 and 4, my lord, adjourn.
3 and 4 you appear.
Millards,
Appearing to 3 and 4.
You want time?
Millards,
25 minutes.
Millards, a humble submission, Millards.
Jagannath Sanskrit Mahavidyalaya, he is appearing for that. He is taking time to file counter.
The counter has already been filed, Millards. We do not wish to file a rejoinder, Millards, because the petitioners wish that this
Readings are complete. Call this matter on 24/10.
Millards, a small submission.
8/10. Yes.
Millards, can it be posted immediately after vacation, Millards?
We have already posted many matters.
Millards,
Yes.
it's a matter relating to examination, Millards.
Which examination?
Millards, 85 number of students were not able to appear in the 12th class plus equivalent +2 examination.
When it was held?
It was held in the month of February. They approached the authorities. The authorities gave a decision rejecting their representation in the month of May. We had approached this honorable court in month of May during the vacation in the vacation bench, Millards. Till date, the matter is going on.
On 9, how many matters are posted? 14. So call this matter on.
Appearing in OP number 5.
OP number 5.
OP number 5, the principal of the school.
Item 57. Item 57.
Yes,
Yes, my lord. Your lordship asked for that petitioner is willing to pay 20,000 at present, and also he has a landed property which my lord had asked that will he create an encumbrance with the High Court registry. He is willing for that.
What is this matter about?
My lord, original mark sheet and certificates are not released by the previous school on account of outstanding fees.
Outstanding fees. Outstanding fees. He is ready to pay the money.
My lords, I appear for the CBSE. The original mark sheets and all the documents have been sent since June 14th, 2024. It's with the school. As your lordship recalls, it's a dispute of that fees, etc.
So not with regard to you, but the school has to give the documents.
And my lord, the stay notice is already served upon OP number 1. He received it. OP number 2 outrightly refused to receive the notice.
OP number 2?
Yeah.
That
the chairman of the trust who manages the school.
Where is that refusal?
Refusal he didn't give in writing. And so
you should file an affidavit saying that he refused.
Today morning only I got that notice
information
from the person whom I have sent to serve the notice.
We'll direct police notice to him.
And one more thing, my lord. Previously, your lordship was pleased to pass an order that seat should be kept vacant by the admitting institution. But there was a miscommunication that the admitting institution already gave provisional admission subject to production of original TC, conduct, and migration certificate, and for verification, original mark sheet and certificates. So they have already granted a seat.
Admission.
They only are saying
these documents.
Yes. And they are saying that within a period of 10 to 15 days, you have to submit it. Otherwise, your admission will get cancelled. So we want, your lordship
We should request them not to cancel. This court, wait, order dated, where is that order? Go to the interim order. By the order submits that. Already the Rishikesh Rai Degree Mahavidyalaya Rourkela has granted a provisional admission to the petitioner, subject to the condition of producing the original marks cards, leaving certificates, and the like.
No, original school living certificate, original conduct, and original migration. Only for verification purpose, certificate and mark sheets.
Original school living certificate, original mark card, and original
Conduct and migration.
conduct and migration certificate, conduct certificate and migration certificate.
And for verification,
Purpose of verification.
class 12 mark sheet and certificate. Class 12 mark sheet, passing mark sheet and certificate.
Of class 12.
12th.
Since there is no response from the OP numbers,
1 and 2.
1 and 2.
One received it.
Production of this document obviously. The said institution is requested not to cancel the provisional admission given to the petitioner. Till next date of hearing. All right, you keep it there. Not good. Learned counsel for the petitioner submits that the second petitioner, namely the chairman of
Vedic Educational Trust,
refused to accept the tender of notice. Therefore, he may be placed ex parte. First, Vedic one is served.
One is the principal of that school.
The OP number 1, represented by the principal, is served with the court notice, and
There is
is unrepresented before this court. First, next paragraph. In the above circumstances, issue police notice to OP numbers 1 and 2, returnable within 1 week. Within 1 week. Not 10 days. Within 10. First, call this matter on 9/10/2020. All right. Next paragraph. The submission of learned counsel for the petitioner that he is claimed to be
20,000 in cash.
You pay 25,000 in cash.
Okay.
25,000, and the remaining amount, when will you pay?
My lord, that I will consult and I will say on the next date only. Because the petitioner number 1, his wife is undergoing treatment. So each injection costs 18,000. So, and he is a ST scheduled tribe fellow. And they are a bit scarce of money. So we will communicate it to the court on 9th.
25,000. If he is ready and willing to deposit rupees 25,000 to the OP number 1. OP number 1. The same is noted. First. He also tells that for the remaining amount, some arrangement is being made. And for that purpose, he needs time.
And till that time, he also agrees that his land documents be kept as a security with the registry.
He further submits that for securing the payment of remainder of the money, he is ready to deposit the title deeds of his land.
Title deeds, ROR?
ROR will be useless, only title deeds.
Okay.
Title deeds of the land while creating equitable mortgage. First,
in view of this fair stand, call this matter on 9/10/2020. All right.
My lord, needless to say, my presence may be noted for other purposes.
The presence of Mr. Patnaik, learned panel counsel appearing for the
OP number 3.
OP number 3. Presence and submission of Sri Patnaik appearing for OP number 3 are noted. Noted.
Item 58.
State, my lord, this is relating to admission in the B.Ed course. The lordship has called for the OMR sheet and on seal cover it has not been produced. Your lordship also kept one seat vacant.
One seat
Vacant.
now. We'll call it after vacation.
Only if my senior will bring the OMR sheet.
OMR sheet. Yes, take that OMR sheet.
Yes,
OMR, the sealed cover.
Yes, yes,
The sealed cover on the instruction of this court is
Original OMR.
opened by the court master.
Original OMR.
Oh, we don't know. After that, we will know. The original OMR sheet.
Yes.
Is it OMR sheet?
OMR sheet.
OMR sheet.
OMR sheet.
The sealed cover is the original OMR sheet of the petitioner. Of the petitioner. Just look into that. Right? The same is faced by counsel for the petitioner.
ঠিক আছে। It is not correct.
It is not correct. Not correct. Yours is not correct, that is not correct.
Yes, signature is not correct, my lord. I will take a copy of this OMR sheet and I will verify it.
Let him take xerox of that.
Yes,
You take the xerox. A photostat of a photostat copy of the OMR sheet generated from the court xerox machine is handed to counsel for the petitioner.
I will verify it
for verification. Right.
In this case, your lordship
machine should not swallow the original.
ନାଇଁ ନବନି ସାର୍ ଟେକି ଦେଇ ମଝିରେ ପକଉନାହାନ୍ତି ପୁରା ଉଠେଇ ଦେଇ ପକାନ୍ତୁ ଏଥିରେ
The original OMR sheet along with the opened unsealed cover is returned to AGA Mr. Do that.
ଏଇଟା ଆର୍କୋଡକୁ ଟିକେ ଛାଡିକି ପକାନ୍ତୁ ହାଫ୍ ଇଞ୍ଚ ଛାଡିକି ପକାନ୍ତୁ ଠିକ ଆସିବ ଏପଟୁ ବାସ୍ ମିଡିଲରେ ବାସ୍ ଏପଟୁ ଭିଡେଇ ଦେଲେ ସେ କଟିଯିବ ସେଠି ଗୋଟେ କପି ଥିବ କପି ମାରିଦେଲେ।
Do you run xerox shop also?
I have sir, 2 machines are with me
in your office.
In my office, one is big, one is small. And this particular model is with me also.
Same model.
For that, without seeing it, I say. And I have done the DCA course in the year 92, my lord. Before coming to this profession also. Diploma in computer academy.
Okay. See that, is it right?
I also.
Give back the original to Mr. G. I delivered back so and Mr. G.
Your lordship had directed to allow me to sit in the class, but it has not been allowed. My lord, senior
Mr. J instructed.
I had already instructed that. Department has issued letter to the Mahavidyalaya, Sadawala.
And they have told that 2 times he has gone, and they told that I will ask the authority and thereafter do.
It was instructed. Today we go.
Just
was instructed.
Yes, ma'am.
He is Attorney General of our High Court.
Yes, I do believe on my big brother also.
No, he does with absolute commitment. By nature, he is like that.
Well, I also.
Should I give it back to them?
No. Yes. Packer, yes. All right, we have retained one copy. We have retained now. One copy. Xerox of you get the Xerox of Xerox. Yes. We'll retain those copy with us. I call this matter on 15.
Yes, interim order
In order to continue.
Item 59.
Yes, sir.
59, my lord. I want some more time to obtain the instruction in regard to the collector's letter dated by the 30th March 2025, my lord.
Call this matter on 23/10 at the request of learned ASC who wants to file a SO counter, failing which, first off, if counter is not filed, petition averments will be taken with face value.
Only instruction was directed. Last order was directed. I have ordered at 12/9/25. Last order.
Government will take decision, my lord. I will communicate that.
So simple.
Yes, my lord. Only by that.
Because that the ASC submits that on the next date of hearing,
My lord.
the compliance of order dated 12/9/2025 would be reported.
Yes, my lord.
Call this matter on the 27. How many matters posted? 9 men. All right. 27. All right. 60.
Item 60.
Yes, brother.
16 is
Similar.
16 is
Here
state
is
of
the case, a promotion is given to me to the post of head clerk. Then it was withdrawn. Then I was challenged before the Honorable Tribunal and State Education Tribunal granted in favor of me. That was challenged by the government in Bipura Lordship. On the last occasion, that took time.
Can you take this matter of vacation?
The date may be fixed.
Date I fix. On 14. How many matters posted?
14. 12 matters. 12 matters.
12 matters. Call this matter on 14. All right. Be ready on 14.
My lord.
All right. Today we have disposed of more matters. I will do.
One submission, the weekly list. There's item number 206. That in that list, it has been mentioned that due to late filing of requisites, the notice could not be served. So only 206. For
Registry to process the delayed submission of requisites.
206.
Immediately. 206. Bit early, I am going back. I have some questions. Yes. By the time I go home, it will be 7:30, sometimes 8 also.
Weekly item.
We post all orders. Weekly we are not. Any urgency?
No, supplementary asana holanda podi janda single.
Gee, you can do it.
Item 1 of the weekly list was